presentation of the Parliament Channel and Parliament Radio 105.5 FM.
The Honourable, the Deputy Speaker.
As we resume after tea, I will recognize the member for St. Augustine. You have 3 more minutes of your initial 30-minute speaking time, and you have your additional 15 minutes. Do you care to avail yourself of the 15 minutes one time? All right, so proceed.
Thank you very much. Mr. Deputy Speaker, when we took the break for tea, I was on the point of the condemnation by the Attorney General in the former Minister of Legal Affairs not having renewed a contract or licensing of a system that was used to basically control all electronic records of this sovereign nation of Trinidad and Tobago. I've been making the point, and for continuity I shall say this, that it would have been unacceptable in the extreme for a sovereign nation and a government that cares about its people and the security of its official documents, and as everyone has said, title to land is crucially important. And it came to my attention then, in 2010, that this licensing agreement allowed a foreign entity, literally, to own the intellectual property, which is the database for land titles. If I'm wrong, I wish to be corrected, but that is my understanding. And that we had to pay an exorbitant amount of money into the millions of US dollars for the privilege of using the system. I thought that it was a noose around the neck of Trinidad and Tobago. And wanting to ensure the safety, to ensure the protection of our data, we said we had to do it differently. And instead of renewing the lease or the contract that came up for renewal, we decided then that we will continue the system, but on a, not as a full 5-year or whatever the term was at the time, contract, but to allow payments as we proceeded with an instruction to the Registrar General to facilitate some other means, a new system to be employed. And to that end, as the Attorney General rightly had pointed out, there had been a loan negotiated by the government for the development of the registry and for the provision of the registration of titles and a host of other things. And in fact, Mr. Deputy Speaker, it'll be important to note that in the years 2011 to 2014, there was a midterm policy framework entered into by the government of the Republic of Trinidad and Tobago. And it was for a 4-year national development agenda. And if you'll permit me, Mr. Speaker, one of the framework's main thrusts is to expand investment, both local and foreign, the government of the Republic of Trinidad and Tobago has identified improving the ease of property registration as a measure that will promote investment. The government's decision to focus on improving the ease of property registration is supported by studies which correlate property rights, protection, and investment. So that money had been sourced to do these things. And now, where we were met with this, as I say, noose around the neck of Trinidad and Tobago, that decision was taken not to renew, and to further efforts using the IDB resources possibly to find another possibility to do it. But the Attorney General, I'm sure, would have kept us updated as to whether they have in fact been able to have achieved that, or whether we have renegotiated, and I know he's a great negotiator, with Massey and others, and to continue the thing. So I really do want to hear then, if it is renegotiated, whether the intellectual property resides in the owner of the technology or in the people of Trinidad and Tobago. That is crucially important. So, Mr. Speaker, there was another issue, and it is this. Registration of land titles, important, yes. And it was at one time the one place that you could do these things was in Port of Spain. But we have old people in particular who are interested in ensuring continuity in terms of passing on and their property to their children and grandchildren, who wanted to confirm sometimes that their title was updated, and they would have no choice but to leave from Cedras, Icacos, Daventil, Port Tobago, Point Fortin, you name it, every corner, Toco, to come to Port of Spain to do it. And when I had referenced earlier the opening of the offices, full-fledged offices in Arima, and during the tea break, I got a call from former Member of Parliament, Sir Roger Samuels, who has advised me that even though the doors might be open in Arima, basically it is as if it's closed. Something has gone wrong in terms of the provision of services. But one of the things to ensure that land titles and other things, other documentation and access to the population was made readily available. Mr. Deputy Speaker, and you, I know you're a very practical man, would appreciate this. What we did is that we opened 14 offices, regional offices in every regional corporation. What we did, with the assistance of the then permanent secretary, was to negotiate with the regional corporations to give us a room free of any rent. And what we did, with the assistance of that great team from Legal Affairs, under the guidance of Ms. Bridgewater, Mr. Sandy, Ms. Moonan, is that we put equipment, computer, in each of those 14 offices and train staff at the head office and put staff, member for Port South, in those offices so that our citizens didn't have to travel to Port of Spain, but they could travel to a close location. Contrary to all that had been said in the propaganda, do you know the first office that we opened in Trinidad? You know where it was? Remember for Point 14, in Point 14. We opened in Diego Martin. We opened in Chaguanas. We opened in Sangre Grande. We opened everywhere. My heart breaks and bleeds when I have received reports that they've closed many of those offices. I don't know why. Maybe there's good reason. But what I do know is that access to the people's business has been severely curtailed by those actions. What we also did, because registration of titles, as I mentioned before, about and the old people, old elderly in our society always want to ensure that things are done well. But when they do pass, what we also put in those offices was an access to registrars of deaths. So that on weekends even, and I remember years ago, my brother-in-law's father had died at Mount Hope, and we needed to get a death certificate. And we had to search, I didn't know Tunapuna as well as I do now, sir, up into the hills to find a registrar. It was not an easy task. And when we got to the registrar's home, he was cooking. And we had to wait till he was finished with his business. And I mean, I understand these things. But in the grief that we were enduring, we had that further burden of first finding a registrar, and then two, making ourselves available to his convenience. And we thought that it was wrong. And when we were given the authority to fix things, we did. So I really do hope, if it is that they've closed offices, to revisit this thing, to ensure that access is made available throughout the length and breadth of Trinidad and Tobago. But, Mr. Speaker, in relation to the electronic recording of titles and this new system, we must not avoid what culturally is a reality. In our country, there are many who still believe that unless you hold the paper, you don't hold anything. And therefore, the transition that I've heard of, which we must do over time certainly, to go completely paperless and electronic, we must bear in mind that the new system must also cater for those who wish to have the old-time document, a tangible thing, a paper that they could hold, feel, and read as a sense of comfort to our citizens. And therefore, I ask the government to move cautiously, if we can proceed in an immediate near future, to the adoption of this new system, to appreciate that need. So there must be at least Attorney General, and I know you listen, and when good ideas come to you, you do take them on board. And I'm sure almost because of the staff that we have at Legal Affairs, they too would also endorse that we must maintain a dual system of the paper and of the electronics. To do otherwise is to avoid the reality of our people in Trinidad and Tobago. Now, Mr. Speaker, I am very passionate about human rights, property rights, civil rights, and a host of other things. But in every system, there are always failures. As it is now, you can have a certified copy of a deed. You are the true owner, the legitimate owner, and you can be the victim of the worst of things. I will tell that story another day. I myself was a victim. My family and I, and in fact, let me talk it before somebody else misrepresents it. In 2016, where I live, beautiful place, the property next door, the bank had seized it from its former owner. An agent for sale came to us and said, and I speak because I speak as a family, not just myself, that this place is for sale, and there were several persons who were interested in purchasing this property. But because we live next door, they also wanted us to know if we had any interest to purchase it, because maybe one of those who might have been interested may not have been of the best character. As a matter for ensuring peace and quiet enjoyment to the property, we bought the property from the bank legitimately, purchased this thing in December of 2016. What happens at the end of January of 2018? On a Saturday evening, a band of men who we thought were bandits came and attempted to cut the lock to enter that property next door. It is most relevant because it deals with title. We call the police, and they arrive within a short period of time. Mr. Speaker, I'm being disturbed, but this is a serious business because this is a personal experience of a real-life situation that many in the society have faced and may continue to face unless we fix it. So, when the police arrived, the former owner turned up and said she is the owner of the property. I said, no, this is not true. This thing was purchased in 2016, in December. The long and short of it is, because I did not have in my possession, member for Laventil West, because I didn't have a physical possession of the deed, and she had an old deed, the police put us out of that property and put her in. They did illegally. And I assure you of this. I've spoken to most learned senior counsel, Mr. Maraj, Ramesh Lawrence Maraj, who has agreed to lead an action against the police for what they did. We had to endure a living nightmare, and I shan't go into the details here, but I will make it known to the public as we proceed. Because in that environment, you know, they had certain media persons.
Honorable member, again, tie it in quickly,
Yes.
right? You have made the point. So
yeah.
tie it in and you can move on to your next
I'm
point.
most grateful, Mr. Speaker. The point I'm making is in that period, the most awful allegations were put into the public domain on a total falsehood. And I, as a member of parliament, had to, endure it and wait for the court to decide, which it did last Thursday. And we got justice in the courts after a month and 2 weeks. Legal, legitimate owner, but because you didn't have the actual deed in your hand, police took a decision that is illegal and ensured that a person who was wanting to steal a home stole it for 6 weeks. That is not the end. Rent-free? Not just rent-free, we were terrorized. But the point I'm making is that this thing about registration of a title, you could have paper or whatever, but unless the law enforcement in the country appreciate that people have their legitimate rights and are willing to protect it, then none of it matters. You see, there are other societies, when things fall apart, when property rights are not protected, and certainly we don't have our physical rights being protected in this country, but I, as a member of parliament, and I asked for no favor except for the protection of the law, became a victim of it, me and my entire family, then I became very afraid of what could happen in this nation. It is not without precedent, Mr. Speaker, and you know of this case. You care about people and you know about this case. Mr. Devnarayan Sukhdev, on the 6th of December 2014, member for Laventil West, awoke not because he was finished sleeping. He awoke to the noise of backhoes and heavy machinery. You know Helping Hand grounds, people? Right off the highway. St. Augustine, my constituency. And there presented to him were police officers fully armed. Evict the man from his home. And we're not talking, and whether it's a humble home or a mansion, a man's home is his castle, this is his home. It was a substantial 2-story concrete structure, well put, and the kind of property that all they want to overtax, right? They put this man out because somebody presented a deed.
Member, again, the debate is concerning the registration of titles.
Yes.
And I know, members, I'm on my legs, and you continue to bring stories or instances with regards where the TTPS, and you are trying to, I don't know if you're trying to put the TTPS in a certain light.
No.
But please be careful, keep it tight, and make your point.
Yeah.
Facts, I mean.
For the record, Mr. Speaker, there could be no greater friend to the TTPS than the People's Partnership Government and the member for St. Augustine. And for those who run amiss of it and give them all a bad name, it is to them we must deal. But the point I'm building to, and if you'll permit me this, so it'll become abundantly clear even to you, that he was evicted. No, when I say, for all of us, because you have not seen the point, and I will make it clear, it's my fault, that he was evicted from his home, and in his presence, the building was bulldozed. Thank God for a lawyer named Larry Lala who turned up. I called him. He went, by which time, of course, the building was in ruin, rubble on the ground. Do you know it turned out, member for Port of Spain South, that when matters were filed in the court, the deed that the police felt that they were acting under law with was a fraudulent one?
That is the issue.
That is the issue. So that, member for Port of Spain, you understand these things, the seriousness of this. So you have your legitimate right, you have your deed, you have everything, but somebody come with a fraudulent one, and they bulldoze your home under gun by the police, which was the same thing that happened to me at 11 o'clock in the night when 10 police officers with machine gun came to my home to put a person who attempted to steal a home back into possession. So the point I'm making, we have to protect our citizens.
And remember, your 15 minutes has since elapsed.
I'm finished?
Yes, sir.
Take my seat. I thank you very much.
I recognize the member for Laventille West.
Thank you very much, Mr. Deputy Speaker, for my opportunity on behalf of the people of Laventille West, as I'm entitled to do in this honorable place, to make a short presentation on the matter before us, an act to amend the Registration of Titles to Land Act of 2000. In light of the comments of the last speaker, I am obliged to say a couple words in response a passant, if you would permit me, Mr. Speaker. Firstly, as I understand it, the police in all of these matters are not there to decide on ownership or on title, but rather to preserve the peace and to ensure that there are no breaches of the peace. And I'm sure that the police are fully aware of that. I heard my friend, the member for St. Augustine, give example of the gentleman, I can't remember his name, whose house was built, Mr. Cudjoe and so on. Unfortunately, these things have happened in this and other jurisdictions. But I remember the pains of the farmers down at Shagaramas that generated a massive public march to Shagaramas in support of farmers who were equally bulldozed in occupation of agricultural lands for many years, under the very government when the member who just spoke was Minister of Legal Affairs in this country. So I must just remind him of that and tell him do so is not supposed to be so. I empathize with Mr. Cudjoe, no doubt, and I equally empathize with the farmers of Shagaramas and restate the principled and lawful position that the police in the country are not to be the arbiters of any land dispute. As a matter of fact, the measures that are being brought before this House will act as a resolution, as a palliative, if you like, to all of the problems that my friend have just adumbrated. And as a consequence, I expect his support for this package and the particular measure that is before us today. The member for St. Augustine, just a passant, Mr. Deputy Speaker, spoke glowingly about the government of 2010 to 2015, a government of which he was a part. Some people characterize it as a government of big borrow, big spend, big waste, and big took. The government of 2015 to 2020, however, is characterized by stability, institutional replenishing and rebuilding, which the measures before this House are a prime and a wonderful example of. This is about institution replenishing
1 second.
and building.
Member for Chaguanas West, since after tea you have been constantly making these little outbursts across the floor. Please try and minimize.
I rather suspect that at the risk of getting himself diabetes, he had too much sugar in his tea. Gives him extra energy. I thank you. And the member for St. Augustine engaged in, I learned many years ago that man was designed such that his hands are not long enough to pat himself comfortably on the back. And his feet face forward so he can't kick himself somewhere. But I don't know how the member for St. Augustine managed it. I see he was engaged in self-massaging for the last 45 minutes. Thoroughly massaged and titillated himself. Mr. Speaker, the member told us, and more substantively, and he admitted on his legs to this House today that they allowed these measures that the Attorney General presented here today to have lapsed for 5 years and 3 months when they were in the government. He admitted that. And the member for Siparia admitted that as well. They told us by way of excuse, poor excuse I might add, that they had priorities. And he was shameless enough to mention anti-gang law, one of the worst experiences this country ever had, costing us millions of Trinidad and Tobago dollars, caused us grief, caused us a loss of confidence in the police, in the judicial system, the criminal justice system. And the gentleman stands here today, the member, to use that as an example as to why important measures like the one before us today would have lapsed under their gaze. Rather than criticize the Attorney General as the member for Siparia did, she should be praising him. Because in his very busy and hectic legislative agenda, we made room for this important measure in terms of institutional strengthening, with the implications for trade and commerce and ownership and title and settlement and some of these things the members spoke about. So I would want to commend the Attorney General rather than criticize him. They focused rather on the anti-gang laws, the member admitted, and no doubt as well on the very calamitous Clause 34. But that's another matter. We leave that for another time. The member mentioned, and properly so, the building and circumstances in which and at which the Registrar General's office and the land registry, so to speak, was situated was not the best in the world, not designed for that in a modern time. And as such, there were for many years during its occupation there, its existence there, was problematic, the vault and all of these issues, air condition issues, access issues, and certainly those were problematic. What did this, our government do? We developed the government campus on Richmond Street, and we now house the Immigration Department, the Customs Department, the Office of the Attorney General, and as I speak to you, developmental work is taking place in the basement of the Attorney General's tower in order to accommodate the vault. The work is actually happening as I speak in preparation for the measures that we have inside of here today. All of this being done in very difficult economic circumstances. And I would say, let Jah be praised. We are going somewhere. And I'm proud to be a part of this. And the public area would occupy the ground floor of that building. And just as is happening as we speak in terms of the Immigration Department, which was transposed from Frederick Street to the very government campus, we will see that improvement in short order. That's what we do. We build. We are the great architects of the establishment that is Trinidad and Tobago. We build. And I heard the members stumble over the issue of the licenses for the data collection platform, storage system, and the software. It is quite normal, may not necessarily always have to be so, for government to contract with firms, international firms that could provide this software there across the pantheon of the government platform. Across the platform. We have many, whether it's Oracle and many other systems that we purchase. As a developing country, we are at the point now where we must purchase these services. And usually, the vendors put in licensing arrangements where you have to renew these licenses as you proceed over time. And this is one of the reasons why we established the UTT, we funded the St. Augustine, the UE, and we engage, we pay for students abroad on scholarships so that they could get the best that the world has to offer in ICT and other disciplines, so that we hope that they will come and put us in a position one day where we don't have to purchase those services. And that's the whole idea. And that's what we do. And we have to continue to encourage these young people. But that is all it was about. I'm sure I didn't know the exact details, I'm sure that it was. So when he encountered that, not understanding it, they put it at an end and threw the whole thing into topsy-turvy. And left the permanent secretary and the ministry with grappling with ways maybe to resolve the problem, some of which probably we still afflicted by up to this very day. But ignorance is a very, very dark condition, especially when you want to spend money on other things. But we'll deal with that at another time. There'll be time enough. The member for Siparia told us about, she witnessed when we are dealing with the question of registration of titles to land. The last government bulldozing people's home, and she had to go to court and act as senior counsel and all
Member,
of this.
again, the she,
The member for Siparia,
identify
I'm so
properly,
sorry.
please.
I'm so sorry, Mr. Deputy Speaker. But Mr. Deputy Speaker, really, there are deeper issues to this. The question is about housing policy. The last government had one way of dealing with housing policy in this country, and traditionally we have another. Our record shows that you will find public sector housing from the western tip of this country to the eastern tip and in Tobago. All across the country we develop houses and we make them available to citizens at a substantially subsidized and reduced cost. Their policy was to give out land. You hear them asking about land for the landless and the access to a piece of land. And then the persons are left to develop houses. Sometimes one man might be able to afford a wonderful home and his immediate neighbor cannot, so there's a shack next door. We felt that there was a more efficient and a more sensible way of dealing with this. And so this Susulan concept and all of that, while it has its value, we had another approach to dealing with the question of housing in this country, and ours have and will stand the test of Trinidad and Tobago time. Only recently we debated here, and it is all part of the whole issue about registration of title, the valuation of lands, and we passed that legislation in this house. And we found a little objection from folks on the other side. We don't know why. What we do know is that there are some people in this country who don't want to see this situation rationalized and made more efficient and more effective, because as I said in that debate, there are some people who hide wealth in properties. There are some people who are occupying properties that they have no title to, and they acquired it within recent times, including former Caroni lands. And any system of valuation and adjudication of land and registration to title, these are troubling issues, important and good as they are, for all of us, most of us. But there are those who would prefer the situation to remain what it is, so that they could continue to enjoy that which they did not work for. But as the Attorney General, acting in the public interest, always in the best public interest, bringing these measures piece by piece, establishing a structure, an institution, a regime, what will happen eventually is that all anti-slopers will be found out. There will come a day when they will have to come out of the hole like Zandoli and declare, this is mine if you really want it. That is what is worrying them. Because they are on record as encouraging people to occupy state lands in this country. They are. Those are the facts.
Member, you care to clarify the day?
Whether day or night, they did it. They did it.
Members, again, Laventil West. I really don't think that's the context that you used it. So please clarify the day, or if not, you move on to your next point.
I'm terribly sorry, Mr. Deputy Speaker. I heard the comment from across the floor, and I thought I heard day. So I was responding to that. My apologies. I'll move on. I'll move on. I'll just move on. I'll move on. Mr. Deputy Speaker. Mr. Deputy Speaker. During the course of the presentation of the member for Siparia, the member observed that the measures that are brought here today in this bill were remarkably similar to that which they allowed to lapse on 3 occasions. And rather than bury their heads in UNC collective shame and embarrassment, nothing is insulting about that.
Members overruled.
Thank you very much. Let me repeat it. Rather than bury their heads in collective UNC, ex-government embarrassment and shame,
Accept that.
The member for Siparia told us here, with great aplomb, that one of the minor changes that we have made is to change the word commit in the context of commits an offense to the words is guilty of an offense. And I rose as an attorney at law. I am no senior counsel.
Neither is she.
Members, listen. Members, again, the little outbursts when the member is on his feet, let's try and minimize it. And if you're saying it, say it in hushed tones, at least it do not reach the speaker's chair. Member for Shogunas East, please. Please. Proceed.
I thank you warmly yet again, Mr. Deputy Speaker. I am no senior counsel, but I felt confident that any senior counsel worth his or her silk ought to easily recognize that that is not a minor change, that is significant. Where we use the word commits an offense, it suggests, or where we use the word guilty of an offense, it suggests that a decision has already been made by those who must charge, because as far as they're concerned, without investigation, the person is guilty of an offense. But there's a larger point. The point is of constitutional effect. And it is that a person under our Constitution is presumed innocent until proven to be otherwise or guilty. And that is a constitutional position that any silk worth his or her silk should know. I rose to my legs and I sought to get the attention of the member for Siparia, and I was flatly rejected, much like Michaela Pandey. But it has to be recorded as the truth. But that's all right. And I see the member for Barataria today in a green shirt. He's saying something. But we will come to that. Mr. Deputy Speaker, in these measures, it is envisaged
Silence.
that the Office of the Adjudicator of Lands, in one of the measures that will come, and that's the next one we'll debate, but the point is this bill makes reference to it, and the valuation bill as well. The Office of the Adjudicator. And when this labyrinth of legislation is eventually put together and on the books, it will lead to a situation where the adjudicator, having taken office, will have a duty under these laws to record title and to adjudicate upon all lands in Trinidad and Tobago, every piece. And in accordance with Clause 85, the present and existing titles and ownership will not be affected. It simply means it will be recorded by the adjudicator. It will be surveyed and adjudicated and settled and title recorded. So we'll be off to a brand new or fresh start. And that is the logic, and that is the common sense and the rational position offered by the Attorney General here today. To my mind, irresistible. In logic, in common sense, in intellect. To my mind, unassailable. And that's why all the positions coming from the other side have been as fleeting and as empty as I'm sure a reasonable observer might find. So we'll be off to a brand new and fresh start in terms. Yes. And then the adjudicator will pass these records of title over to the registrar for registration in accordance with the measures before us here today. In new folios. So we will now have full knowledge of who owns what, and some of the issues raised by the member for St. Augustine and feebly by the member for Siparia. Feebly? Yes. Yes. meaning of feeble. Yes. Will be immediately resolved. So for that reason alone, if I may borrow the words of my friend from Maruga Table and that young, bright historian, man of quality, speaking on that. For that reason alone, we must support these measures. We must support these measures. The two systems that we now know will be maintained. As the Attorney General explained, and those who would have dealt with these matters either as lawyers or as house owners or property owners would have explained, the two systems, the old common law system of transposing title and so on by deed, as opposed to the real property ordinance arrangement, where we transferred by certificate of title. And these measures here will move from what is called certificate of title to certificate of land certificate, Basically, the two systems will continue. But now we'll be operating in full knowledge of it all. And as I said, Clause 83 itself preserves all the rights that now exist. It is simply that they will all be recorded. And then you have the adjudicator, which we'll deal with a little later, who will resolve any issues and make decisions and then pass those to the register for registration accordingly. And that is basically the core of how this thing is supposed to work. What could be troubling my friends on the other side about this? What would have troubled them to the point where 3 times they brought these sensible measures to this house and left it well alone to lapse, and the country continued to wobble along in traditional squalor, and don't want to compliment the AG for sorting it out here today. Look, I want to salute the Attorney General and the government. In my own constituency, only last Saturday, and as I remember that, I have to express a little personal pain. I saw a citizen mouthing off on live Facebook only yesterday, talking about who they can't see and which MP they're not seeing and all of that. Mr. Deputy Speaker, and this is not self-praise, this is a statement of truth. Those who work with me in Laventille West will tell you, we work every single day in the interest of our community, and we work every single day in the interest of this country from the cabinet and from the government. And it pains me to hear people who have no contact with you, know nothing, just glibly mouth off about them and doing nothing, and we can't see them. Well, I don't go to heaven, I may look like that. I'm always right here on this earth. And always somewhere, apart from the 4.5 hours we might sleep when the night comes. Every one of us, on both sides. I don't like talking for my friends on the other side. That's a risky business. But I am sure in this country, every single member of parliament must work and work real hard for the little that we get. We do it out of a commitment to this country. It's true. And it sickens me when I hear people who have no, you hear them. I heard a citizen yesterday describing a high office holder of this country as incompetent, a qualified man holding high office, whatever you think. I heard a citizen describing this high office holder as incompetent, those things, but this is Trinidad, where if you ask 3 people their opinion, you'll get 5. But that's not the point. The real issue here is this. In my own constituency, I met on Saturday with a group of about 60 residents. And there are only 60 of about 450, I am told, who have been in occupation of privately owned lands for 40, 50, 60 years in the Maplands area, Snake Valley area, in my own constituency in Laventille West. Recently, relatively recently, a new owner bought over the title to that land, buying it, no doubt, with full knowledge of those who are in occupation, and is now trying to sell these lands in the respective household plots to these people at all kinds of prices that scare them, that they can't afford. So they came to see the Member of Parliament, and we've had a series of meetings over the last few months. We met last Saturday, and we continue to meet as I put together a team to speak on all of their behalf with the new owner of these properties to see whether we could get the best interests for these people whose grandfathers and whose land is the basis of wealth. People have fought and bled and died for land. A system of slavery developed over land. A system of indentureship developed over land. Land is critical. And the people of Maplands and in Laventille, they understand that. So we are trying to work this out. But I can tell you one thing, the measures that are before us today will certainly be of value to them going forward. And I stand by them as Member of Parliament as we do this. The Attorney General dealt with the particular issues of Tobago, quite lucidly, I might add, and one of my colleagues on this side will deal more emphatically with those issues in this very debate, I anticipate. The member for Siparia, I must tell you, Apasa, the member for Siparia criticized the Attorney General and our government about poor accommodation of the building and all of that. The very member, you know, the very member as a Minister of Education oversaw the purchase of an old warehouse on Sackville Street at great expense that within 1 week of purchase was deemed unfit for human habitation. It stands cold and empty to this very day. To put a model school for the children who made less than 30% or so in the SEA. She was quite prepared, the member for Siparia, as Minister of Education, administering state policy to dump those children inside of that building that was declared unfit for human habitation. I called it Kamla Sek. Fortunately, the government changed, and those very children were put in more congenial circumstances, more conducive to teaching and learning. And if the Minister of Education, another very distinguished contributor, upon whom an attack was placed in this place, but through the power of the Most High,
Member,
he came out surfacing.
different point.
I thank you very warmly. I thank you very warmly. But God is such a great God. Somebody admitted that they did wrong. And it is now on public record. Let me turn swiftly to clause 12 of this bill, which seeks to amend sections 24 and 25 of the Act, where, as I alluded to, APASA, the benefit of the citizens of this country, where we will move from what is known as certificate of title to land certificate. And very significantly, in clause 13, we seek to amend section 29 of the Act, in fact, to repeal it and replace it with a following section 29, which says, and I quote, permitting me, Mr. Deputy Speaker, an instrument or document evidencing a dealing has legal effect and passes an estate or interest in land when a memorial is endorsed on the folio under the signature of the registrar. What does that mean for the benefit of the layperson? It simply means that once the registrar signs the folio, the interest or the estate or the title is deemed to have passed from one owner to the next. As it now exists, it is on the certificate of title that this endorsement is made. And that endorsement, based on the slowness and the bureaucracy of the system, could take a very long time from the day it was executed, from the day the interest was supposed to have been transferred, or the estate, or the value, the property. It could take a long time between that and the signing and accept or receipt of the certificate of title. This is a significant advance on that inefficient position. This says from the day the registrar signs that folio, the transfer is effected. that makes a lot of difference. So again, a sensible.
Remember, your initial 30 minutes has expired. You have an additional 15. You care to avail yourself?
Definitively, Mr. Speaker.
Proceed.
You wouldn't find that one in the dictionary. That's mine. But I mean, yes. Clause 14 seeks to amend Section 30 of the Act by repealing subsection 1 and substituting that with a section. I wouldn't trouble us members present to read it. In fact, I think for the benefit of the viewers, I should. It says, and this is the substituted, rectification is the side note, rectification by the registrar. The registrar may rectify the register or any instrument presented for registration in the following cases. So this really outlines the circumstances by which the registrar, the person with the ultimate responsibility for these titles, their accuracy, their record, their preservation, because all of these are very public documents. If I have to do a transaction in land, I'll want to be able to go somewhere and see what is the status of that land. Who owns it, in what circumstances, at what price, and at what date. All these are very pertinent facts, germane to any decision I must make to purchase title. So this new provision is identifying, Mr. Deputy Speaker, the circumstances by which or in which the registrar may change or rectify what is on the record. A, in formal matters and in case of errors or omissions not materially affecting the interest. So if in the opinion of the registrar, legally trained as she is, hardworking as the incumbent certainly is, and who must be commended, because while we debate these matters in this house, a lot of work was done behind the scenes to get us to this point. I want to commend the registrar, all her staff, the attorney general, the lawyers at the Attorney General Office, who have been working assiduously, week after week, to get us to where we are. So that if in the opinion of the registrar, there's any matter that does not materially affect the interest or the title, a rectification can easily be made. It's allowable in law. B, in any case, at any time with the consent of all parties interested. So in terms of interested parties, if there's consent, a rectification can be effected or made by the registrar. C, whereupon resurvey, as I said, the lands will be resurveyed and the adjudicator will then settle them all to pass on to the registrar. Whereupon resurvey, an area shown in the register is found to be incorrect, but in such case, the registrar shall first give notice to all persons appearing by the register to be interested or affected of his intention to rectify. So if the registrar identifies some kind of incorrect registration, she has a duty in law to notify all affected or interested persons. And once they are notified and hopefully agree without challenge, then it can be rectified accordingly. And if perchance they have any query or dissatisfaction with it, this is where the adjudicator, which we'll come to a little later, will play a significant role. And finally, in this provision, upon receipt of any decision of the land tribunal, we have another part of this package. It's all patchwork coming together to make us a wonderful legal labyrinth or quilt that we could sleep and rest comfortably on, if I may use a metaphor. And so, Mr. Deputy Speaker, clauses 12, 13, and 14 make major advancements on what now exists. As I said at the top of my short contribution, in an attempt to rationalize this business of registration of title and all of the peripheral matters that must come in place. I give my friend, the member for St. Augustine, the assurance. He didn't have to plead his case here. We all read in the newspaper about his personal troubles with his neighbor. Nobody asked him that. He has come today and he has given a version of this story. But as a lawyer, I know there are always three sides. His side, she side, and the truth. And the truth shall set us free. I've heard the member for St. Augustine in this house already make loud claims that I, on my personal investigation, found not to be so. But I have no axe to grind in this matter, so I'd leave it until another time. So, Mr. Deputy Speaker, I promised you a few words. And with those few words, I would like to say to my friends on the other side, what is in front of you reflects good sense, deep thought, intellectual pursuit, and it is simply good for Trinidad and Tobago. And for those reasons alone, I urge you to cut out the time wasting and lend your support to these matters, and you will be doing so unusually in the public interest of Trinidad and Tobago. I thank you.
I recognize the member for Caroni Central.
Thank you very much, Mr. Deputy Speaker. I wanted, first of all, in my contribution to this bill, to deal with a few clauses and to raise some questions about them, and to talk a little bit about the business of land. Because in our system, under our system of public administration, you have basically a ministry responsible for the legal matters related to land. It may be based on the evolution of that ministry, Attorney General's Office or Ministry of Legal Affairs, and now it is the Ministry of Legal Affairs, that deals with the business of registration of land. And the registration of land there will cover both state lands and private lands. And these bills, the 2000 parent bill, as well as the amendments to that particular bill, and the bill we are debating here now is an act to amend the Registration of Titles to Land Act 2000 and the amendments to that. The bill that we are debating now really acknowledges that there is a deficiency in the registration process, which we are seeking to fix. And we spent 18 years to get to this point to try and fix it. But there is another administrative aspect of land, which is that there's always a ministry under whose jurisdiction land falls. In the current administration, land falls under the Ministry of Agriculture. In the last administration, the administration in which I served as a minister, there was a ministry responsible for lands. And in addition to that, there's always a ministry involved in planning for development purposes, where permissions are granted both for the development of state land as well as private lands. So when you're dealing with the business of registration of titles to lands, you're not just dealing with the issue of registration. You are dealing with the business of land ownership, property matters, and you are also dealing with the matter of development. And having said that, I want to frame my contribution in the context of this understanding of what we are doing here today. But my colleague and friend, member for Laventille West, I couldn't let him get away with some of the things that he said in his contribution. You know, sometimes, no, you didn't tell me nothing, but he came, sometimes I think that he plays the role in the government of, first of all, entertainer. I think that's a personal choice. Secondly, he plays the role of protector of the realm. You know, he has to defend the realm, and he has to make sure that he secures the realm. And he makes his pitch to the supporters of the realm, the member for Laventille West. And the third role that he plays is the role of agent provocateur to the opposition. And basically...
Member, one sec. I have a standing order there. In terms of...
48.1 irrelevance.
Members, I am on my legs, first of all, and I'm making a judgment. Kindly proceed.
Thank you, sir. So, the leader of the opposition, for instance, when she made her presentation, she acknowledged the journey from the 2000 bill to now and the various attempts to bring it to the floor of this honorable House. But she said that except for certain reservations that she had, the leader of the opposition indicated that we want to support the bill because basically it was a bill that had its birth, so to speak, had its birth in a certain administration 18 years ago, and which we had in fact agreed to bring to the Parliament. But yet the member talked about, he spoke as if we were opposed to certain things for the bill. He imputed motives. And I find it really, really problematic, the kind of presentation that he made before he got into some of the clauses of the bill. He talked about the Chagaramas farmers, the member for Laventille West. Talked about the Chagaramas farmers. I wouldn't say anything about that except to say that the matter of the Chagaramas farmers was settled in court. It was a matter that came before the court. It was settled. And the court settled in favor of the Chagaramas Development Authority. That is a fact of law and a fact of history. Any other thing is an interpretation or a political stance on the issue. He talked about the fact that the member for Laventille West, he talked about the fact that his government, speaking on behalf, playing the role of protector of the realm, he said his government was a builder. So I just want to take the opportunity to remind this honorable House and to remind the population of how well they have built the sea bridge, how well they are building the air bridge, and how perfectly they are building the Tobago economy. I could say more on this, Mr. Deputy Speaker, but I will leave the contribution of the member for Laventille West with only one more point. And that is he pointed out that there was a difference in the approach to housing and property ownership policy between his government and our government. And I want to say, yes, that is true. Our approach to land and property and home ownership is to spread the business of land ownership across the population. That's the first thing. And the reason for that is because land ownership and property ownership is the beginning of the process of capital accumulation in the notion of land, labor, and capital. The second thing is that we are committed to the notion of home ownership, because when you have massive home ownership in a society with the notion of property ownership, people have a stake in the society. They also have a stake in the financial side of the economy because they now own equity. And therefore, they can be a player, a leverager of an asset which is theirs and has property value to make a difference in the economic system for themselves and their family. And the third thing is that we believe in employee share ownership. We believe that if employees in a country, whether they work for the state or whether they work for the private sector, if they own shares, you are likely to get higher productivity, you are likely to get greater company loyalty, and more than that, in addition to all of these things, you are likely to get a certain amount of stability in your labor participation pool in the economy that you are trying to develop. So I want to emphasize that there is a difference in policy between the government and the opposition, and that the big difference in policy is that we believe in widespread land ownership. We believe in widespread home ownership. We believe in widespread employee share ownership so that a worker is not simply a wage earner in the society. I move on now to the bill itself, and I want to say that there are some issues raised here that I want to perhaps spend a minute or two on. The first thing is the issue of digitization. I want to say it is a hopeless exercise to talk about the business of registration of land unless digitization is at the center of that process. This is the 21st century, Mr. Deputy Speaker. It is not the 18th century. And in the 21st century, if you are going to have a registry of land ownership, you might have it in books, that is fine. But the place to have it is to have a digitized system in which every single piece of land is recorded. The second thing is that I want to mention in relation to digitization, and the leader of the opposition mentioned it, that there was a cadastral management system, a CMIS project, that we supported and got off the ground that needs to continue to be supported now. And secondly, the geographic information system, we established a board to develop and overlook the development of that. I don't know if the board exists. I think the board was summarily fired during the ascendancy to office of the last administration. If I'm wrong, I can be corrected. But if you are serious about land in this country, you need to deal with the cadastral management system, and you need to deal with the geographic information system in the mapping process and in the delineation of boundaries, etc., so you understand the ownership of land and its links to the registration process. I do want to say, though, as I go into the particular bill, I want to say that I think the members on this side have already indicated that the land registry has in fact collapsed and is very, very dysfunctional. I think the did so on the basis of anecdotal instances that they put forward, and also the Attorney General himself admitted, he didn't admit that it collapsed, but he did admit that there were problems with it, and I will take that. I move on. And I think the other thing we need to admit as we deal with this business of land registration, Mr. Deputy Speaker, is the fact that fraudulent transactions occur. And if you are going to have a land registry and you're going to have land registration and you're going to have law governing land registration, then the admission or the acknowledgement of the reality of fraud in the system needs to be taken into account. The member for Siparia and leader of the opposition also linked this. I mentioned the registry, the ownership of land, and the development of land. But she also linked this to the ease of doing business. And it is true, in our time, there was a link between the Ministry of Industry and the Ministry of Planning. And the objective was, of course, in the ease of doing business, to address this issue not only of land registration, but land transfer as a factor in the ease of doing business process. And we were using models that had been established elsewhere, and using, I think, the World Bank at the time. I'm not sure if the IDB was involved in that project. I cannot correctly remember now. But we were using that. I think the European Union was also involved in that particular project. But the ease of doing business is something that is facilitated by the land registration, the effective land registration process. So I want to go on to the bill itself. I have some notes here on the member for St. Joseph, and I have some notes on the AG's contribution, but I think those have been adequately dealt with by other members on our side, including the leader of the opposition and the member for Oropouche East. So I will go on to some of the substantive issues in the bill. As has been said here before, this bill was assented to on July 13, 2000, but it was not proclaimed. When you look at the bill, that's to say the original bill that is now being amended, when you look at the amendments, to the original bill, at one level, the amendments may be regarded as administrative or cosmetic. So there is that. At a second level, there are ambiguities in the parent bill that are being addressed in this bill in order to clarify certain things in the bill. Thirdly, there are certain processes that are fine-tuned within the working functions of the registry under this act. So you have the appointment, for instance, of the people who will be in charge. And secondly, you have a process by which this is done. And from the parent bill, what you have really in the bill is the centralization and streamlining of land registration in Trinidad and Tobago. And if you centralize and you streamline, that would add structure and consistency, which is currently lacking in the conveyancing industry. So it is a useful bill, which is why the leader of the opposition said that we have no problem once we get clarification on certain things, once we look at certain things in supporting it. But that does not mean that the bill does not need to be carefully looked at, because the leader of the opposition was right. This bill is 18 years old, and the world has changed 1,800 times since 18 years ago. And the whole situation in Trinidad and Tobago is something that is worth looking at again if we are going to finally proclaim this bill with amendments. And therefore, a review of the bill, which need not be a long process, is something that might be useful for this particular bill. Because I want to note, and I think the Attorney General would admit this, there is no overhaul of the registration process itself by either the bill itself or the amendments. There is no real overhaul of the registration process and the amendments. And I am not sure that the links between the registry all right, and the land ownership ministry in terms of the designation of lands and the Ministry of Planning. I'm not sure, that's to say, the having to do with the development issues. I do not know how well integrated those are going to be if we do not have the, what you call it, the cadastral management information system and the geographic information system in place and intact. So I want to raise some issues. I raised the issue of fraudulence. There are no penalties that I can discern in this bill or in the amendments that are included in respect of actual fraud committed in the registry or by the general public. The Attorney General can correct me if I am wrong, but I don't see in the bill or the amendments any penalties with respect to actual fraud committed in the registry. You do? You want to clarify?
I'm so sorry to do this, but just for guidance, Mr. Deputy Speaker, what the honourable member is discussing is very relevant, but is squarely anchored in the land adjudication bill, the GIS mapping, the cadastral. Quite a few speakers have spoken, and I don't want to interrupt the honourable member, but I'm wrestling with where the boundaries of the other bills in anticipation begin. So I don't want to raise an objection per se, but I'd like the honourable member to sort of guide it to the bill with your direction. I'm just raising an observation because it is squarely, the entire system of mapping, etc., is in land adjudication, and then there are processes that go to the tribunal. This is the disadvantage of doing these bills separately because they are intended to be articulated together.
In terms of the explanation given by the AG and with the other bills to come, you know, at least let's see how quick you can tie in the point, and you know you can move on to the other point, but you're going fine.
Okay. Mr. Deputy Speaker, all I will say is that the issue I'm raising here is the issue of penalties for fraud. So, and we must have penalties for fraud because you cannot assume that we have an incorruptible system. You cannot assume that people will be above the law. You cannot assume that there are some people who are all-powerful and cannot be touched. And you cannot assume that the issue of fraudulent activity will just be ignored by the bill. So I want to emphasize the need to include that in the bill. Item 14 of the bill, which amends Section 30 of the Act. A few questions arise, Mr. Deputy Speaker. There is a notion here of formal matters, right? In Part A of Section 31 and 2 of the bill. It is very difficult to say what formal matters covers, what the term formal matters covers. And I think that there is need for some kind of definition of that, so it is clear that it is not a catch-all phrase for everything, and it is well defined as to what these formal matters are. Then another issue is, should there not be a cap or a limit to the number of persons from whom consent is required to make rectifications in the register? For instance, this notion of interested parties. Anybody could be an interested party, but they must have either a financial interest or they must have some claim to beneficial interest in the property that is being registered. So I think that needs to be circumscribed so it is not just anybody who could declare an interest. It has to be tied to some notion related to the business of land ownership and the registration of land. Okay, if you say so.
Members, one sec. Again, Honorable AG, again, in terms of the information, you may have it at your fingertips in terms of the bills that we are debating, right? But when we come to the information that's being divulged at this time, you know, we'll have to see how it goes in order for the member to make his presentation.
Not engage you, sir, at all, and I apologize to my little colleague. Honorable Deputy Speaker, they are in the other bills which are on the order paper, and therefore we have anticipatory notice of that. The difficulty in the opposition's approach in separating out the bills is that all of what my learned colleague is saying, beneficial ownership, etc., is squarely in the adjudication bills. So it's difficult to have this sort of arrangement, and I just say that for the record.
No, okay, Mr. Deputy Speaker, I think you know as well as the Attorney General, he knows that there is a standing order against anticipation of a bill to be debated. That's the first thing. And secondly, I'm raising these points in relation to this bill. When the Attorney General comes to debate the bill he is referring to, he can explain it contextually. You know, that's what a parliament is for.
Mr. Deputy Speaker, Standing Order 51. That standing order is very clear, and if I may be allowed, it shall be out of order to anticipate a bill by discussion upon a motion dealing with the subject matter of that bill. It shall be out of order to anticipate a bill or notice of motion by discussion upon an amendment or a motion for the adjournment of the House. In determining whether discussion is out of order on the grounds of anticipation, regard shall be had by the chair to the probability of the matter anticipated being brought before the House within a reasonable time. And Mr. Deputy Speaker, at this time, the information that is being debated or discussed by the member is in the adjudication bill, and it is also in the land tribunal bill. Both, but you should, both of which have been on the order paper for several weeks, and we have had first reading of those bills, Mr. Deputy Speaker. So I can't understand, my friend.
Okay. Member? Okay, let's tie it in quickly and let's move on.
No, sir.
No,
with all due respect.
No, I'm giving you the permission to continue. But I'm just saying to tie it in and bring it in quickly in terms of what was just identified with regards to Standing Order 51, anticipation.
Yes. You know, if the government has a problem with me speaking, they must let me know. But I have the freedom to speak. And I want to tell them that when they stop me here, I will go elsewhere. And if they stop me elsewhere, I will go elsewhere. Let me tell you something. And I am prepared to go on the pavement. All right?
Member, honorable member, again, you have my protection. I have ruled and I have said that proceed, tie it in, and let's move on with regards to what was just identified.
Yes. I want to raise, Mr. Deputy Speaker, and I think it's another question worth asking. Is there or will there be sufficient physical manpower to bring about the change and efficiency envisioned in this act, in this bill? The leader of the opposition raised the issue of the allocation of funds in relation to the development of this particular ministry and this particular function. So the HR, the technical competence, the infrastructure issue, both hard and soft, in order to facilitate the effective functioning of this bill. What about willpower, Mr. Deputy Speaker? Currently, the land registry faces significant constraints and challenges which impact on the legal fraternity. It impacts on the ordinary citizen or the public at large. And I think that this is something that we need to appreciate, that you cannot just legislate for or establish in the legislation the proposed infrastructure for allowing these things to happen. There has to be a will at work in order to make these things happen. In section 4 in the amendments, what exactly or precisely is meant by, and I quote from it, validation under the hand of the registrar? I think that needs to be explained so that there is clarity about what validation means, Okay, this is land we are dealing with. This is law we are dealing with. This is process and precision in language that we are dealing with. And therefore, these things need to be attended to within the law. They must not be subject to interpretation. And why create the conditions for testing in court? So, the leader of the opposition often intervenes to say that we want to see good law passed. And therefore, if we can take care of these little details, it will make things a lot better. So this needs to be clarified, explained, and made explicit. Clause 13 of the bill. Clause 13 of the bill repeals and replaces Section 29 with a new Section 29. How is the old section changed by the new section? I don't detect the change. The effect of the new section is to state that an instrument requires an endorsement from the registrar to be effective.
Honorable Member, your initial 30 minutes has expired. You have an additional 15. You care to avail yourself?
I would like to, Mr.
Proceed.
Deputy Speaker. Thank you very much. Mr. Deputy Speaker, can I appeal to you for injury time for the intervention? My colleagues.
For their injury.
Proceed, member. I will decide when that time.
Yes, okay. Okay, so this is the endorsement from the registrar. Now, what is the legal status of a document which is tendered for registration but not yet validated? You see, that's why I'm asking the question by the registrar. This is in section 4.4, as I mentioned before. How do you deal with the time between registration and validation? What is the status of the documents? What is the status of ownership? What is the status of registration? So in that hiatus between the registration and validation, do we have a little problem that we need to address or explain or clarify or find a formula for greater precision in the management of these things? Is there an additional period of time under Section 4.4 for the instruments to become effective under this section? So I think that that is something should be addressed. Clause 14, while there is reason in the registrar being able to rectify as set out in the proposed Section 31, we have no problem with that. You need to have somebody who's adjudicating, so to speak, the process. There seems to be a problem, and I quote what I think presents the problem. In any case, at any time, with the consent of all persons interested. I raised that earlier. Those words, persons interested, makes the catchment very, very wide. So I think that needs to be clarified. Why not refer rectification issues, for instance, to the very land tribunal that the Attorney General was referring to just now? Clauses 15 and 16, Section 41 of the Act dealing with executions out of the jurisdiction, and Section 60 of the Act are not addressed in this amendment bill. There is big fraud in matters dealing with land, as I said before, and that is increasing. And there are also cases of fraud involving documents executed abroad, and that is becoming as big a problem as the one locally. So should we not pay more careful attention to Section 41 of the Act? As I have said, as the member for Oropuch East has said, as the leader of the opposition has said, 18 years have passed since the bill was attested to, and perhaps the bill itself needs to be looked at a little more carefully. Now, if you had, in Section 60, how would this impact on persons seeking a mortgage with the related transfer being by way of a gift? there is the notion here of transfer. But what if the transfer were not a paid transaction and it were by way of a gift? Would that have any implications for the registration and the process and the implications for dealing with the matter within the financial system? And clause 20, I think the leader of the opposition focused on that as one of the main issues with which she was concerned. It amends section 73, which allows for inspection of copies of records. And the issue is public access, public use, citizen freedom in accessing all of this information and transparency in the system. I think what you need here is an electronic system that actually works and which can be remotely accessed so that all citizens who have that facility can have access, but also equal access to the documented version outside of the online version, in which through a process that is properly managed, effectively managed, any citizen can exercise his right as a citizen to find out about the issue of land ownership, whether his land, her land, or somebody else's land. Now, the issue of accountability in the search process, I don't think it will be such a problem in the electronic version. But if a fraud takes place when you are dealing with the books, I heard in this particular debate issues about pages being torn out and being replaced and so on. How do you, first of all, protect and secure the system? The member for St. Augustine talked about electronic eyes that had been put in. I don't know if that still prevails or what the situation is. And secondly, how you would deal with transgression in such a situation, which is a serious issue because you are really altering the registry in order to change ownership of land. So that becomes a serious issue. And there's the issue of certification. Will all be certified by the state? Will there be some official searches and some unofficial searches? And how do you deal with the business of searches?
Mr. Deputy Speaker, I invite you to look at Standing Order 55-1B in terms of tedious repetition.
Again, member for Caroni Central. That particular point has been identified by 3 other speakers so far for today. So again, please tie it in quickly and move on, right? The same digitizing, the same digital, what you spoke about even earlier. So again, in terms of moving on, please.
Well, I didn't realize I was repeating something. I will proceed. How many minutes do I have again?
You have just about 8 minutes, sir.
All right, that's enough for what I need to do. The issue of land use, planning permission, and development parameters within a planning and development framework arise because of this bill. It raises the issue of the bill and its proclamation and its application as law. Because we laid in this parliament in 2013 the spatial strategy document for Trinidad and Tobago. And we also passed, I think in that same year, I may be wrong about that, it may have been 2014, I'm not sure, an act to amend the registration of, sorry, we also passed in that same year the bill to facilitate, in 2014, sorry, that was in 2014, an act relating to the planning and development of land and to repeal and replace the Town and Country Planning Act. And that bill speaks about decentralization, devolution, integrated planning, a national planning authority, etc. All of it dealing with land and development. And that takes me back to my earliest point that I made at the start of the debate, that when you're dealing with this registration process, you have to take into account these things having to do with planning and development, but also the business of the ministry responsible for the ownership of land. And I say that, and I close on this, just this one point, is that in the Planning and Facilitation of Development Bill, it would have referred to this 2000 Act, which we are now amending. And secondly, it would have referred to the real property system, or the RPO system, which basically we are eliminating as we move to a new system of the management of land. So that this bill will require an amendment of this Planning and Facilitation Bill for the bill to function. And I know that the bill has not yet been proclaimed, only part of it has been proclaimed. And what I am asking really is whether enough consideration has been given in the government to what are the implications of these bills to other elements of the land management system executed and exercised by the state, and whether these things have been thought through. And I want to say, have they been thought through in terms of the notion that while you have a centralized registry, you also have a commitment by this government and a commitment in the National Spatial Strategy and in this Planning and Facilitation and Development Bill to devolution. And therefore, you need land registries that are accessible as well.
Mr. Deputy Speaker, I again ask you to consider Standing Order 55-1B. Yes, I'm miserable in terms of tedious repetition.
Member, this is your last point, you said?
Yes, I'm closing my
All right, so,
debate.
okay, so let's close off accordingly, please now.
But Mr. Deputy Speaker, there is nothing that I'm saying here that is repeated before.
Member, I'm giving you the opportunity to just close off your point, because again, member, you have, it's a repetition that you have mentioned earlier with regards to land ownership, development, decentralization. I have the jottings here. So I'm saying, as you are winding up, I'm giving you the opportunity to wind up and finish the point. Proceed.
Mr. Deputy Speaker, I am illustrating that there is legislation and policy statements by the government that require decentralization and devolution, and they therefore require a thoughtful appreciation of these things if these bills are to make sense. And I would say,
And member, and
yes.
the point has been made. Could you move to your next point? Members?
And I would like to say, Mr. Deputy Speaker, that as far as I know, the Parliament is for this free speech of the elected members of the House. And I would like to say that no obstructionist in whatever office.
With regards to your remark, I really don't know who you're referring to.
I'm referring to the leader of the House.
Well, okay, member, in that case, you can have your seat. I will now recognize the next member.
Are you denying me the right to speak if I have a half a minute, Mr. Deputy?
Member for
Deputy
Tobago.
Speaker, Mr.
Member
Deputy
for
Speaker.
Tobago West.
Yes, thank you very much, Mr. Deputy Speaker. I thank you. I thank you for this opportunity to contribute this afternoon. And Mr. Deputy Speaker, I must say I stand here. I'm making my contribution. I stand here in awe, Mr. Deputy Speaker. Yes, I am amazed. I stand here in awe. I must say that, Mr. Deputy Speaker, because some of the things that they on that side get away with, we can't dare imagine. Anyway, Mr. Deputy Speaker, I am here this afternoon to make this contribution to this land registration matter. And I want to address two matters raised by the previous MP while he was in, before he took off. Now, Mr. Deputy Speaker, he spoke about housing, and he was saying that the opposition, they have a different housing policy when they are interested in housing for all, Mr. Deputy Speaker. And I want to say that we on this side, we are interested and we are championing housing for all. Also, a matter of fact, it is not just about building housing, it is also about making lands available for housing. Mr. Deputy Speaker, I am a part of a cabinet that would have recently passed provisions relating to a land policy where people who have lands that are participating in our new housing program, when they build houses to provide to the public, the government subsidize or provide subvention assistance to the tune of $100,000. In addition to that, if you want to participate in the program and you don't have land, we are making lands available in order to allow proper housing for the people of Trinidad and Tobago. And the People's National Movement have been involved in this housing business for years, providing hundreds, thousands of houses to people, for people throughout Trinidad and Tobago. And the difference, Mr. Deputy Speaker, is that we do it in a strategized way. Mr. Deputy Speaker, it is much more organized, and it is not a corrupt system like we have experienced under their government with the whole EMBD situation, Mr. Deputy Speaker. So I wanted to make that point. The member for Caroni Central would have also raised the matter of digitalization, and I want to say to Trinidad and Tobago, through you, Mr. Deputy Speaker, that we all could be rest assured that this government, we have continued, a matter of fact, we have advanced the cadastral management system, and we met this morning, down to this morning, with the officials that are responsible for surveying and mapping, Mr. Deputy Speaker, so that we can make the cadastral management system a part of the IDB project, which you would hear some more about later on. In addition to the GIS, and the cadastral mapping system is also a part of our PSIP. This year, Mr. Deputy Speaker, I want to also speak to the advancement of the GIS system that the member would have mentioned. And I'm pleased to say that that project is advancing very well, to the point that we are almost to 100% coverage of state lands throughout Trinidad and Tobago. And that is the work of this People's National Movement in our 2.5 years. But Mr. Deputy Speaker, I want to come off of his topics. And I want to say first and foremost how pleased I am to be a part of this government, to be a part of this People's National Movement administration that is before this Parliament today in order to advance this piece of legislation. I am glad that this is finally before us. Mr. Deputy Speaker, I championed this cause, Mr. Deputy Speaker. I campaigned on this matter of land registration and land titles and solving these issues for the Tobagoanians. So I am pleased to be a part of the delivery, and I'm pleased to be a part of the delivery of this piece of legislation at this point, because it's not 2 days before an election or 2 weeks before an election like we had become accustomed to under their administration. So, Mr. Deputy Speaker, many governments would have come and gone over the years that would have promised to resolve this matter. And if you listen to the debate and the intelligent discussion coming from this side, it goes all the way back to more than 18 years ago. And I would have witnessed some in my time while I was in opposition, Mr. Deputy Speaker, and when I checked the records in doing research for this debate today, you would have seen several times where the debates would have lapsed, the discussions would have lapsed, Mr. Deputy Speaker. You would have seen several studies, all the way down to the Gaya-Prasad studies in the 1980s, Mr. Deputy Speaker, all the way to the studies done by Mrs. Eastland Mackenzie, or should I say former Senator Eastland Mackenzie, and even later on, following those consultations and discussion documents, work done by Deborah Moore McGinnis of Tobago also. So government after government, debate after debate, this thing had lapsed so many times. But I want to say, Mr. Deputy Speaker, in order to get meaningful land reform in Trinidad and Tobago, it requires consistent, stable, and mature leadership, Mr. Deputy Speaker. We have to be on one part, moving towards the light, moving towards resolving this matter, and we can't throw it away just because we didn't win an election or just because the government would have changed hands, and that would have happened to us in 2013 in Tobago when the People's Partnership did not win the Tobago House of Assembly election. So the people of Tobago are well aware of what I'm speaking. I know a number of them are looking on today. They would have followed, they constantly were asking on my Facebook page, and when I visit my constituency weekly, a number of people come to me with land registration and land title matters. So I'm pleased that this government is making moves in order to resolve these matters. Now, Mr. Deputy Speaker, as a Caribbean country, because this problem is not about Trinidad and Tobago only. This problem affects the rest of the Caribbean region, and I think it is because of the size of our island. The land space is very small. It's a limited resource, Mr. Deputy Speaker. Because of the makeup, we are close to the sea, so we have to consider protecting the environment, ensuring that there is access so that the public could enjoy the beach, and different provisions of that nature. I want to also speak about our traditions, our beliefs, our customs, our culture, where for the most part our foreparents would pass down land when it's close to their death, and would do so as part of our oral tradition, so there are no real legitimate form or records to really show what has really happened. But we would have a chance to explore that when we speak about the land adjudication matters. But for the most part, governments throughout the Caribbean, we have pretty much grappled with trying to strike a balance between ensuring that land is available to the poor, that we develop a land policy system and a land use system in such a manner that would facilitate investment and productivity. And thirdly, we also grapple with developing our lands and establishing a land management and administration system so that we can protect our natural resources and make the best use of the little piece of land space that we all enjoy. So, and speak, he would have raised the Sandals project, Mr. Deputy Speaker, and this is about productivity and investments. And you would have heard the concerns coming from the tourism sector. While I wasn't here last Friday, Minister Ayanna Webster-Roy, who would have acted in my absence, she would have raised the matters relating to land titles and the problems faced by the tourism sector.
Silence.
I wasn't here, Mr. Deputy Speaker, but I did my research and I would not be distracted by those opposites. So, Mr. Deputy Speaker, being a Tobagonian, Mr. Deputy Speaker, a young Tobagonian also, I want to say this matter is it's very close to my heart, Mr. Deputy Speaker. It's not just close to my heart, but also very dear to the people who I represent, Mr. Deputy Speaker, because land is very dear to us. It speaks to wealth, it speaks to ownership, and coming from a tradition, coming from a culture where we are raised on Thank you, Madam Speaker, and welcome. I was saying, being a Tobagonian, a young Tobagonian, and coming from a culture where we are raised on African proverbs and teachings such as, there's an African proverb that says, if you sell your father's land to buy a trumpet, where will you stand to blow it? And that's a Yoruba proverb, Mr. Deputy Speaker, encouraging young people not to sell land to buy frivolous things or material things. It speaks to how important land is to us. There is another teaching where parents constantly say to the children, he who owns the land rules the state. So it is our business as Tobagonians, as young people, from the time you start working to start saving towards acquiring land. And then I come from Bethel Village, Mr.
Madam
Deputy
Speaker, 48-1,
where-
please. Could the minister tie in what it...
Member, please continue.
Thank you, Mr. Deputy Speaker. As I said, I would not be distracted by the opposition. Madam Speaker. So, Madam Speaker, as I said, I came from Bethel Village, where the old men often use a phrase that says, blessed are the man that have his own sword. So, or blessed is the man that has his own things. And so you want to own your land. You want to own your property, Mr. Deputy Speaker. As Tobagonians, that is something that is very dear to our hearts. So, to live in a country with such a small land space, a matter of fact, for Tobago, our situation is a little bit more critical, or should I say more dire, because it's such a small space of land. We are talking about 116 square miles, and everybody wants the opportunity to own a piece of that small piece of land, Mr. Deputy, Madam Speaker, and we want to do so. We want to do so transparently, and we want to do so legitimately. So we all want to have that piece of paper in our hand to say, okay, we own parcel X, parcel Y, parcel Z. Mr. Deputy, Madam Speaker, and that gives us a sense of confidence, a sense of pride. We want to be able to enjoy our property just like our brothers and sisters in Trinidad and throughout the rest of the region. We want that opportunity to go to the bank and provide a deed so you'll be able to take a mortgage, to use your deed and your land documents and so on to acquire a loan to send your children to school, to set up businesses. Because sometimes we...
This is a recording.
Shh, you're not the speaker, relax now.
What is that? Please continue, member.
Thank you, Madam Deputy Speaker. We want to enjoy, Madam Speaker, we want to enjoy our property just like our brothers and sisters in Trinidad and up the region, Madam Speaker, to acquire loans, to stand security so that we can enjoy a better standard of living, Madam Speaker, and we also want to be able to subdivide land so we can pass on to our children. So this matter has plagued Tobago and plagued the nation for over 2 to 3 decades. I would say from time, even from the 1880s, this problem has been happening, Madam Speaker, and it is our business now to bring some relief to the people of Trinidad and Tobago and to the people of Tobago especially.
I need a ruling.
Member, please continue.
Madam Speaker, this issue would have caused much problems for us in Tobago as it relates to poverty alleviation, the ability to, it causes family feud within families, Madam Speaker, and I spoke already about damaging or causing stress as it relates to our quality of life. I want to add another part, Madam Speaker, because I think that this problem as it relates to land titles and land registration in Tobago creates an artificial demand for public housing. Because people who are unable to resolve land matters, to get their deeds in their hand and so on, rather than go through the stressful process of coming to Trinidad and getting the work and going through the natural process that takes years, months, before you can get your deed in your hand, and some of the records cannot be found because of the way we would have practiced passing down land over the years due to oral tradition, and for instance, storing your deed or your land documents, your important documents in your mattress, in some corner in your home. And I know for my mother would store or birth paper and any matters related to land in a grip. And most families in Tobago during those days store their important documents in a grip. And if that house would have burned or you would have moved from one place to another, you have to ensure and secure this grip. Madam Speaker, And a lot of young people don't know what is a grip. So it's like a suitcase, but it's hard. I can't explain it, Madam Deputy Speaker, but I know the average Tobagonian Madam Speaker, the average Tobagonian family knows what a grip is. My mother's grip still exists. If you have seen the Tobago wedding, you would have seen the bride or the women following the bride would have a grip on their head. It's like a suitcase packed with stuff. And that would symbolize moving from a home to somewhere else. Madam Speaker, that land title or deed is usually in that grip.
Member, for point of pair, while the standing orders are available to any member, let's try to use them in a manner that doesn't seem to be if we're ridiculing the standing orders. Member for Tobago West, please continue.
Thank you, Madam Speaker, for allowing good sense to prevail. Madam Speaker, as the member for Caroni Central would have mentioned, being a former minister responsible for planning and development and so on, land is about development. Land ownership is about development. I came out of the hands of, out of the class of Mr. Rennie Dumas, former Tobagonian parliamentarian, and may his good soul rest in peace. But he would always teach me that you can't do any kind of development without land. So resolving land issues in Tobago is so critical, so central to development in Tobago. We can't raise children, educate children, send them out there to learn about the world, to come back to Tobago, to advance Tobago's development without solving these land issues, these land matters, Madam Speaker. So we do this kind of work in his honor and in honor of all the Trinbagonian parliamentarians that would have come before us, that would have been fighting the good battle so that we could enjoy a better quality of life. And I want to speak a little bit, as I spoke about development. It's not just about developing sandals or tourism properties and so on. Look at the matter as it relates to Claude Noel Highway. The Claude Noel Highway was developed before I was born in 1982, Madam Speaker, and to date, the owners of these lands have not been compensated. So it interferes even with development that takes place by the state as it relates to compulsory acquisition. So there are some people that...
Madam Speaker, 48-1, please.
He doesn't understand the bill, that's the problem.
Member for Tobago West, the member is entitled to raise a standing order. The presiding officer will rule on it, okay? All right, so we have allowed you a lot of leeway. I think now all that you've said is a foundation. If you can tie it in now, please, to the courses of the bill before us.
My pleasure, Madam Speaker. So this piece of legislation, along with the different provisions and the different systems that come with it, will help to resolve this matter so that these people could be compensated and so that the government could properly conduct its business. The culture and the history of Tobago plays an important role also. The history would have shown that the bulk of the land was owned by estate owners or slave owners and so on. So as soon as land, when the PNM came into power in Tobago, we decided as soon as land come on the market that we would purchase these lands. Hence the reason we have heritage estates. So you have Pigeon Point Heritage Estate, Friendship Heritage Estate, Pembroke Heritage Estate, and we continue to accumulate land for the development of Tobagonians. Now, Madam Deputy Speaker, I want to spend a little time on this fact that government after government would have spoken to or would have promised to resolve this matter. And I sat here today and I listened carefully to the Member of Parliament from St. Augustine, who would have been the Minister of Legal Affairs in the previous government. And he spoke about an event that took place on January 14th in 2013, where they were able to resolve this matter and to bring relief to the people of Tobago. And I remember being in opposition at that time. And as a Tobagonian, I'm very much aware of what happened. So I want to be able to get the opportunity, Madam Speaker, to place on record my recollection of what happened and what was also reported in The Guardian of that year, Madam Madam Speaker. Madam Speaker, the member of Siparia would have also spoken to the same event where the 94-year-old citizen would have cried by finally getting his deed in his hand and so on. They came to Tobago and put on this whole show. Now, mind you, the 14th of January 2013 would have been exactly 7 days before the Tobago House of Assembly election. So they came into power in May 2010 and waited until 7 days before the Tobago House of Assembly election to stage this relief effort to Tobagoanians. And allow me to read what the Guardian says. And I quote, this is the Member of Parliament for Siparia saying, "How pleased I am to be able to deliver on my government's promise to regularize the land title situation that has for so long plagued Tobago. Pleased and relieved for the recipients who have endured an interminable and unconscionable wait for this day." End of quote, the Prime Minister said, listing the reasons why this could not have been done before by the government. She said it was because of a laid-back custom and culture of the times.
Could the member kindly leave the chamber, please? Please continue, member for Tobago West.
Thank you. So, Madam Speaker, there was much song and dance about relieving Tobago and finally solving this matter as it relates to land reform and land title. Madam Speaker, where are we today? The situation still exists. And on top of that, Madam Speaker, I'm here to tell you that those 19 people that received these land titles, as they claim, Madam Speaker, when they opened the titles, it was blank pieces. Madam Speaker, yes, it was blank pieces of paper.
Unbelievable.
Madam Speaker, it was blank pieces of paper, and they promised the people.
Please continue, member for Tobago West.
Thank you, Madam Speaker. And they're telling me prove it, Madam Speaker, and I want to take you there with me. So it was blank pieces of paper because the people were complaining after, and they promised them that in due time that they are going to fix it. Now I'm saying, Madam Speaker, they brought the process to a point, but never completed it to let these people have legitimate paperwork and documents in their hand. Madam Speaker, and when he was speaking, I got up because Member Hinds from Lavantil West said, go investigate, because I remember what happened. He said, go investigate that, and I ran outside, and I called a member who was a part of the committee that they would have set up in Tobago. And that member was able to tell me that, yes, it was blank papers, and a matter of fact, they brought them up to the point where you get a certificate of title, and then you have to advertise. You have to do an advertisement to see if anybody has any issues with it. Any issues with it? Please. Madam Speaker? And so the issues were never resolved. A matter of fact, one of the lawyers that I spoke to today is still looking at 5 of those matters out of the 19, and one of the clients unfortunately died a couple weeks ago and wasn't able to see this thing to fruition, Madam Deputy Speaker. And further, prior to, the lawyer was also a member of the committee, and the lawyer said, you know, we did good work. We did consultations. We went around to the different villages and got the information. But as soon as they lost that election, they abandoned the entire process. So yes, you would have bring relief to 19 people by taking the process up to the point of advertisement. But it was never completed to give these people the legitimate pieces of paper, the legitimate document, the land title in their hand. And so I know of these 5 matters that are still with that specific lawyer. And I can speak to that, Madam Speaker, because when I got out of school in 1998, waiting on my CXC results, I worked at this law firm that pretty much did the paperwork and so on. They pretty much specialized in handling land matters. And at that time, Mr. Taylor was the professional in Tobago and that, and he died, and then other lawyers took it over. So I'm quite familiar with what is outstanding and what needs to take place. And I can tell you that matter has not been resolved. The committee had not met not one day after they lost the election on January 21st, 2013. So, Madam Speaker, I want you to understand the excitement and why I'm pleased to be here today to actually see this bill advance. In the interest of the people, of Trinidad, and more so, the interest of the people of Tobago. Madam Speaker, another thing, I learned, this is my 8th year as a parliamentarian, Madam Speaker, and I've seen budget after budget and provision after provision and promise after promise, but I know, as Stalin says, without money to buy honey, you're looking for misery. So, Madam Speaker, if you don't have money to finance that said project or plan, it's not happening. So we could plan, we could have consultation, we could tinker the legislation, because that's what we have been doing over the years, tinkering the legislation. A matter of fact, the member opposite said what we're doing here are cosmetic changes. Madam Speaker, what we are doing here to do is making the necessary changes and amendments that were required by the IDB. And why are we catering to the IDB in this regard? Because the IDB is providing the necessary funding to make this happen. So it's not about amending the legislation only. We could amend the legislation day in, day out, but nothing happens without the money. And this time around, this government, alongside this legislation, alongside this entire package, Madam Speaker, we are doing this IDB project that will include notification, the surveying and mapping, Madam Speaker, the cadastral management system.
I just want to interrupt here. I keep hearing members talking about package. I believe there's one piece, one bill before us. Okay? And, you know, if we're going into other things, one bill being debated one at a time. So I just want all members to be quite careful about this package and about going into things like surveying, GIS, and mapping and all those sort of things. Please.
Thank you, Madam Speaker. I would have raised that to bring to the fore. The IDB project covers the provision of all of them. So whilst we are debating titles, the IDB project touches this Bill number 1, Bill number 2, and Bill number 3. So it's all connected, but I'll try to stay on course with the titles matter, Madam Speaker. So with every step, and especially for this land title matter, comes with this IDB project that has the necessary funding in order to really bring relief, because as I said, nothing happens without money. So, Madam Speaker, I just want to close on saying, yes, development is a continuum, or it takes place from step to step, year to year, decade to decade, term to term. We pass the baton and we keep on running. Just because you've lost an election or the people of Tobago didn't favor you and may never favor you, mean you must put it down. So, Madam Speaker, I want to say I'm pleased to be here, to be a part of this, and to see this come to the fore, and to bring relief to the people of Tobago. I want to commend the Attorney General. I want to commend also the Prime Minister Tobagonian, who is trying to make sure that Tobagonians are able to get their land titles and so on. And I'm here as representative for Tobago West, Ayana Webster-Roy as representative for Tobago East, and we would ensure that this debate doesn't lapse. We would ensure that this project is not aborted, so that people of Tobago could have their land titles and enjoy a proper quality of life. So, Madam Speaker, with that said, I want to thank you.
Member for Oropuch West.
Ensure the galleon's passage.
Thank you, Madam Speaker, for this opportunity to contribute to this bill. After I've heard a member for Tobago West so agitated this evening, Madam Speaker, I feel compelled and I have to respond to her. Madam Speaker, the honourable member said land titles always plagued Tobago for 2 to 3 decades. I want to remind the honourable minister that PNM was in government for 50 years. And what have they done? 50 years they were in power. It took a People's Partnership government under the astute leadership of Kamla Prasad Bisesa for the first time ever to give out 19 titles to Tobago people. Madam Speaker, The honorable member said that there were blank pages. I want to ask the member that when you speak, you must take ownership of what you say. And you must bring documentary evidence to show, because you could only say things. She said, the honorable member said that just a while ago, and you say things without proof, having evidence. Things don't work so. Madam Speaker, she called someone and get hearsay. Hearsay could only be allowed if it's done contemporaneously. Madam Speaker, PM, what is the other things you said? The honorable member said, Madam Speaker.
Nothing of significance.
The honorable members said on January 14th, 2013, the honorable member for St. Augustine came and gave out sheets of paper. What he did, the honorable member did, is that he set the foundation for PNM to continue the work, Madam Speaker. What PNM did is that they dismantled what the People's Partnership had established in Tobago. Madam Speaker, the honorable member said... Sorry.
No conduct.
Sorry.
Continue, member for Oakwood.
Madam Speaker, no matter which government is in power, there must be continuity with what is established.
What is good?
And what is good for the people of the island, the people of the Trinidad and Tobago, the citizens of the country. The honorable member for Tobago West said she was not there last week, and the member for Tobago East represented her. And Madam Speaker, I just want to quote from what the member for Tobago East said. She said, Mr. Deputy Speaker, this particular bill we are debating will contribute towards restoring the economy of Tobago. It will breathe life into the economy of Tobago. As I said before, it will help to support and bolster the tourism sector. This is what the member for Tobago East said. Madam Speaker, which Tobagoan want to hear about land titles now? They want to get a boat, Madam Speaker. They don't want to hear about land titles now. Which tourist come into a country because the title is registered?
While I understand what you're trying to do, I'm not going to let you expand this to anything about boat or tourism. Please keep it within the confines of this matter.
Madam Speaker, this is what was said by the member for Tobago East.
Member, I'm sure. Member, I'm sure you don't mean to question what I've ruled, okay? I said I understand what you're trying to do, but this is not a debate about the economy. It is not a debate about the boat. It is not a debate about tourism. Please.
Madam Speaker, the honorable member for Tobago West spoke about the digitized system, and they are making it work. But I have a letter here from the Title Abstractors Association of Trinidad and Tobago, Madam Speaker. The digitized system, when you go onto the system, what you will get is a prompt that comes up. OSA is disabled. OSA is disabled means that you cannot get the document in the digitized system. So I'm not sure what this member was speaking about if the digitized system is not working.
I invite you to look at Standing Order 55-1B, please.
I am
Okay, so members, just for us to remember, when a member stands on a standing order, the member who is speaking will sit. The speaker will then rule, and hopefully the speaker will be allowed to rule in silence, silence being observed by both sides. When the speaker rules, the person who is on their legs, who was on their legs, is entitled to continue based on the ruling. Okay? Member for Oropouche West, I will allow you some leeway. Please continue.
Thank you. Thank you, Madam Speaker. Madam Speaker, there is something called also the PIMS system, which is Property Information Management System. What we have right now at Port of Spain, we got only 4 computers, Madam Speaker, for title abstractors. 4 computers, you have 100 persons who would line up to get titles for financial institutions, to get titles for attorneys at law, for conveyancing clerks, and so. And every time, Madam Speaker, they go to take abstract information, they got to pay what is called a voucher, $50 voucher. And every time that voucher, they have to use it for 15 minutes or so, their computer. And there is no guarantee using this PIM system that they are going to get any title abstract. So this is what is happening right now, Madam Speaker, in the land registry. I also listened, Madam Speaker, attentively to the Honorable Attorney General. And I really tried to dissect his several pronouncements advanced, Madam Speaker. I try really to discern the usefulness of this bill at this time and whether passing these various amendments will really provide an enabling environment to make it easier for the proprietors, for attorneys at law, and the financial institutions to register land titles more easily. I ask, Madam Speaker, would these various amendments to the bill really effect any tangible changes to the bureaucracy and the red tape that plague every institution under this PNM government? Madam Speaker, registering titles is not a simple process. It is a complex process. And I think that rather than the Attorney General rush to pass legislation to register titles of land, he must first fix the institutions that are plagued with mediocrity. Those very institutions, Madam Speaker, that have to aid in the registration of titles. And those such institutions, I refer to the Lands and Surveys Department. I refer to the Valuation Department. I refer to the Commissioner of State Lands Department. These are different departments, even in Town and Country Planning Division. And I could give a simple example, Madam Speaker. Take, for example, a mother who has 4 acres of land, agricultural lands, and she has 4 daughters. She wants to give those 4 daughters 1 acre each. Those lands will have to be subdivided into what is called portion plans. Those portion plans must not be sent to be...
So, member, in terms of land registration of title, I will ask you very quickly to tie what you're saying into it. Because so far, I'm not seeing the connection, but I'll give you a quick opportunity to do that.
Madam Speaker, what I'm saying is that the Town and Country Planning Division will refuse that subdivision, and you cannot get your titles registered. That is what I'm saying, because the title, you have to fix the Town and Country Planning Division.
So no matter how good your intention is.
Madam Speaker, if we look at section or clause 25A, what will be issued is what is called a land certificate under the registration of title. And what does the land certificate represent? It represents the date of issue of that land certificate. It shows the parent folio. It shows the name of the registered proprietors. Under the Real Property Ordinance, Madam Speaker, owners of land are called really proprietors. It shows the name of the estate or the interest that is held, whether the person holds the interest as joint tenant or tenant in common. And most importantly, it shows the schedule of the land with all the encumbrances which are endorsed and which would be endorsed to the back of the certificate. So it's one of the ways in which you could pick up a land certificate and see all the memorials which are endorsed, so you'll know all the transactions that take place. So what happens, Madam Speaker, with this land certificate, it seeks to make ownership and the transfer of land more reliable under this registered system. It serves as evidence of ownership, Madam Speaker. But what happens is that sometimes with the new turn in the law, even though you have this land certificate that shows all the memorial endorsed, at one, you could have your title extinguished, even though you would have learned in law school, Madam Speaker, that this title is indefeasible. It can still be defeated once there is something called adverse possession. So that we'll deal with that when we deal with the other matter of the Adjudication Act. The other clause, Madam Speaker, clause 14, amends Section 31 of the Act to give the registrar the powers of rectification in case of errors or omissions not materially affecting the interests of any proprietor. Madam Speaker, this section, this clause 14, Madam Speaker, these are powers that are already inherent in a Registrar General. These are powers of rectification are already inherent in her. So what I'm saying, Madam Speaker, is that what should happen is that the powers should be given to her more discretionary, meaning, take for example, like there's a constituent of mine. His name is spelled with an S instead of a Z. He has a certificate of title, Madam Speaker. That name change is from an S to a Z. So perhaps like Fazal, instead of F-A-Z-A-L, it is F-A-S-A-L. That certificate is sitting at the Registrar General for the last 5 years. The Registrar General cannot change S to a Z. So what I'm saying, Madam Speaker, where it does not materially affect the interests of the proprietor, the Registrar General should have more discretionary powers instead of certificate of title sitting there for 5 and 6 years. The other discretionary power, Madam Speaker, sometimes attorneys may register a memorandum of mortgage in the form of a common law structure, a common law format. And what happens is that that memorandum of mortgage is registered and placed in a separate index. So what we have is some credit unions, they register charge on land, so they could register mortgages on lands. So it is registered in a credit union, placed in a separate index. But when you as a landowner now go to the registry to register this land title, it doesn't show up because it is in a separate index. So this clause here, clause 15, which amends Section 35 of the Act, which will operate subject to Section 34(2), persons contracting with registered proprietors ought to be aware that there are instances where legal interest in a parcel of land might not be reflected on the register and separate inquiries will be necessary. Madam Speaker, this is a good clause because it protects the purchaser also. The other situation, Madam Speaker, is that since you cannot get right now, trying to get a search properly done, there's something called lis pendens and judgments. And when you want to register titles, take for example, you want to buy land, due diligence will dictate that you do a search. And you have to find out whether those lands are encumbered. So you want to buy land, you don't have the money, so you have to go to the bank. The bank also will not lend you money until the bank has done its proper search, which is due diligence. And if you cannot show up whether the lands are encumbered, whether it's subject to encumbrance, lis pendens or judgment, then both sides, you cannot buy, and neither the bank would not lend you. So there are great difficulties, there are many problems before we could really start registering lands, Madam Speaker, because every institution, as I said before, there are cloaked with bureaucracy. Even in a land registry, it is difficult to get clear titles. The other point, Madam Speaker, is like, take for example a person who was registering his title. He was preparing to get a land certificate, which we are doing now. And he dies during the process. What happens? He dies, he's preparing to give his children the land, and he dies. The usual thing, Madam Speaker, is that he cannot register until he gets a grant, until his estate is probated if he dies testate, or letters of administration if he dies intestate. So you cannot get a grant, you cannot register your land and continue the process until you get a grant in your hand. So you could do a memorandum of assent to whosoever the administrator wants, or if the executor wants. Right? But what happens, Madam Speaker, is that at the probate court, it's like pulling teeth. So you can't get anything done. Right? So,
what is before us, please? Please relate that to this.
So, Madam Speaker, what will happen is that the process cannot continue. You cannot do a transfer. The interest cannot pass on. And the title cannot pass on. This is what the point I'm showing. So, Madam Speaker, as much as this is a good bill, we have also, I believe, from Clause 4 to Clause 8, where a senior assistant registrar will help in, I don't know if it's to expedite matters, but I am trying to figure out if one senior assistant registrar in any way can help to help move the process forward, because you have over maybe thousands of titles to be certified. So, Madam Speaker, with these few words, I thank you for this opportunity.
Attorney General.
President. Madam President, give me, oh, sorry, I was in the Senate this week as well. Forgive me, sometimes I'm sitting in both houses at the same time. Madam Speaker, it gives me great pleasure to bring conclusion to this debate. The honourable members opposite have, notwithstanding a few protestations, indicated that they are in general support of the measures before the House today, and I wish to thank them for their contributions. Indeed, it was difficult to stand at times to try to urge members to stick to one bill. Just for the purposes of that explanation, lest members think that we were being uncharitable, Madam Speaker, it's really just because there are several bills on the order paper. We're debating one of them today. It is opposite to the best use of Parliament's time that we, in fact, do them together. But regrettably, that's not the approach that has been taken, because one requires agreement to get there. I do hope, however, that bearing in mind that we've gotten past the registration of titles bill, hopefully by the end of this afternoon, that my learned colleagues opposite would see the wisdom in taking the rest of the legislation together, because it's hard, if I were to put it into an example form, to discuss the merit of a moving car when you have to pass the engine separately from the transmission, separate from the axle, separate from the gas, separate from the keys. So I urge my learned colleagues opposite to bring some sense to the manner in which we use the time in this Parliament, and I'll say no more on that. Madam President, Madam Speaker, forgive me, Madam Speaker, the bill before us is 23 clauses long. We're treating with the primary legislation which is before us. We're treating with laws which were passed in the year 2000. We're dealing with the Registration of Title to Lands Act, which of course is Act number 16 of 2000. The Leader of the Opposition raised the question that this particular bill does not have a proclamation clause in it,
and she wondered what would happen upon the assent of the bill as it relates to the operationalization of the larger scheme. And permit me to start by addressing that point. The fact is, Madam Speaker, that Section 2 of the Parent Act, Section 1, forgive me, of the Parent Act, provides that the Act itself shall come into operation on such date as is fixed by proclamation and published in the Gazette. This Act, the Primary Act number 16 of 2000, was assented to. It has stood on the books as laws of Trinidad and Tobago for the last 18 years, and we are, Madam Speaker, in a proper position by this bill to amend the Act number 16 of 2000 and then seek to proclaim the Parent Act. Madam Speaker, we were asked how quickly we are in a position to treat with the proclamation. And I'll answer that question now. The proclamation will ultimately be tied into the ability of the Parliament to pass the three other bills which are related to this particular bill. And without anticipating those, they include the land adjudication mechanism, the land tribunal mechanism, and the state lands amendments that we propose. Those three must come together. So I'm answering that question by saying that we must, as a Parliament, agree upon the sensible utilization of our time, take all those together, and then move towards proclamation. Proclamation is also impacted upon some of the work that the Honourable Member for Tobago West traversed, and that has to do with the operationalization that has gone on in a number of areas, and I'll put them out in point form. One, and I'll drill into this in better detail, in the information strengthening that we have done at the Land Registry, that is a division of the Ministry of Legal Affairs, which is a division of the Attorney General and Legal Affairs Ministry. Two, at the Ministry of Agriculture, Lands and Fisheries, where we have the work product and the cadastral information management system and the GIS system, which speaks to where our state and condition is in land management. Three, insofar as we have operationalized loans from the IDB, firstly to the tune of $8 million for the island of Tobago and $100 million for the island of Trinidad. Fourthly, in terms of the general connection in the rollout plan, and I will say squarely that we intend to begin the rollout plan in the island of Tobago, where the title situation is by far the worst. Now, Madam Speaker, we heard the honourable members say something which was rather curious. First of all, they said, this is a copy and paste exercise of UNC work. There are 6 amendments that are different from the UNC bills, and there were 3 of them in the period of the 10th Republican Parliament. And this work is therefore nothing that is genuine. What have you done in 2.5 years? Why are you only now bringing this? Let me explain the logical and associative understanding that stands behind how you approach laws. Madam Speaker, perhaps the number one issue alongside the issue of the economy is that of crime. The country cannot wait for crime to be solved fast enough. And the government therefore invested its first amount of work in the criminal justice system. And you will recall that we were very dedicated sitting. I sat in the House and in the Senate, sometimes up to 4 times a week. 4 times a week in the 2.5 years that we've been there. So we spent our time treating with the criminal justice system. Madam Speaker, further, the bill before us today is directly related to the others on the order paper. Yes, the land package, as some have referred to it. But it is also extremely relevant to note that this bill is related to the follow the money package that we are bringing to the Parliament in a matter of weeks. Further, Madam Speaker, it is directly related to the work that we are doing on account of international obligations, be it FATCA, next on deck the Global Forum, and the Financial Action Task Force and CFATF arrangements. You see, all of those elements articulate together. You have to have a criminal justice system that is functioning to allow for prosecution for money laundering and proceeds of crime, etc. You have to have your land package and follow the money together so that you understand the database that you're treating with, because the proceeds of crime get parked in land, cash, or businesses. Land is by far the element that is under the most amount of abuse. The most amount of abuse is in the abuse in the system of registration and fraud that is perpetuated. The ability to hold people accountable so that you can track their criminality in the follow the money arrangement is found in land. So it is immature from a learned colleague's opposite to say, what you did in 2.5 years, why you didn't bring it now? Why you allowed the bill to lapse? We allowed this bill to lapse because we weren't ready to treat with it yet. And very importantly, we insisted that we were able to operationalize the law. And let me give you an example. This law is to be operationalized in the same way that we as a government will have made history and have made history in the passage of laws to treat with the creation of a family and children division, in amending 19 pieces of law, in perfecting all of the regulations, in perfecting all of the job positions and creations, be it in TTPS, be it in child probation officers, be it in children's attorneys, in the whatever. In creating that operationalization, this bill is being operationalized at the same time. So that as we did an 18-month package to open courts, as we have, we're able to do the same thing here. And that's why, Madam Speaker, we distinguish ourselves from the work product of the UNC. Now, let me address something that the member for Siparia said. Member for Siparia said, you've done nothing for Tobago. The member for St. Augustine repeated, it was almost as if he used the word murder, that there was murder towards Tobago, and he meant it not in any pejorative fashion, but he was using a description in terms of the system that he alleged was cannibalized in Tobago. And he said that Tobago had not delivered what it was supposed to have. Madam Speaker, the fact is that the UNC and the Honourable Member for Caroni Central sought to distinguish his position for his party, the Honourable Member, from that raised by the Member for Laventille West, in saying that there was a different manner in which the opposition, as government, treated with the concept of property, treated with the concept of capital, treated with the concept of citizens' entitlement. But I want to put on the record, Madam Speaker, the UNC brought 3 versions of this bill, 2011, 2012, and again in 2012, all lapsed. The UNC brought the Land Tenant Security of Tenure Act 2013. They brought a Land Security of Tenure Act 2014, lapsed. Wow. The UNC brought the State Land Regularization of Tenure Bill, lapsed on 17 June 2015. And let me tell you, just to answer in a very short form, what that means for the people of Trinidad and Tobago. And this is in direct answer to my learned colleague, the Honourable Member for Caroni Central. You see, Madam Speaker, that last bill that I mentioned was a bill to say to squatters who, under this piece of law which we propose as a bill and amendment, will have the right through a registration process to have their adverse possession recognized, because this bill allows for adverse possession recognition. The Honourable Member, in distinguishing the UNC's position, failed to mention that there was a fraud perpetuated on the people of Trinidad and Tobago. And I say this figuratively speaking, if not in deeper sense, because the legislation which came to this House, that bill to deal with security of tenure, Madam President, That really was Madam Speaker, that really was a terrible bill. It was a short bill which basically said, we'll shift the date for certificates of comfort, which can then progress to a deed, passing through lease, etc. We'll shift the date for certificates of comfort instead of the time frame ending 1 year after 1998. In other words, then your cutoff date is just at the end of 1999, because that's the law. You cannot get a certificate of comfort if you were on lands after the year 2000. They brought a bill to the Parliament consisting of 23 pages of bill. And they basically said to citizens in Trinidad and Tobago, go forth and squat. Yes. And do so generously. And hurry up, because we're bringing law in the form of the bill that I've mentioned, which is going to allow you to have 3 years after 2015 becomes assented as your cutoff date. Right? That is what was said. It's said in clause 4. 3 years from the commencement of the State Lands Regularization of Tenure Amendment Act 2015. And Madam Speaker, hear what was done to the people of Trinidad and Tobago. Page upon page, here's the designation. Albert Trace, Matura. Alexandra Trace, Valencia. Guayco, Tamana. I've given you the property descriptions. Guayco, Tamana. Macoya, Tunapuna. Maraval, Maraval. That was the definition of the areas where you could go and squat. Let me repeat that.
Maraval.
Maraval, Maraval. What? So the whole of Maraval, just go and squat.
What?
Guayco, Guayco.
What?
Farm Road, St. Joseph.
No big joke.
Monrepo, St. Anne's. Mount Hope, in Mount Hope. Madam Speaker, let me tell you why this was the worst fraud on the people of Trinidad and Tobago. You know that under the law, the Ministry of Planning, same act that the member for Caroni Central referred to and asked about the Planning and Facilitation Bill, and it was supposed to replace the planning legislation we had. That honourable member, educated as the honourable member is, knows fully well that you had to have had the planning certification and plan for these areas developed alongside this law, which was not done. Let me translate that. Bill says, go and squat generously in Trinidad and Tobago. People in Monrepo squat in Monrepo. People in Guayco squat in Guayco. No plan, no demarcation, nothing. That's what the UNC did to the people of Trinidad and Tobago. So most respectfully, Madam Speaker, I take no lesson from that form of sleight of hand and dishonesty that was perpetuated on the Trinidad and Tobago, where it was a paper mache passed off as a healthy body. Madam Speaker, that really is not the kind of lesson we want to be led by. Madam Speaker, we heard members ask, where are the regulations? Madam Speaker, you heard that? My learned colleague said nothing happened in the period of the 2.5 years. Why did you bring a bill and no regulations? Madam Speaker, the regulations were finished since 2005. They had the regulations for a full 5 years. Honourable Member for St. Augustine. The bill came 3 times under your hand. 3 times with no regulations. The regulations under the Act which we are amending, 82.2, say that the regulations must be done by negative resolution. Madam Speaker, don't come and ask us for regulations today when you had the regulations in your hands and you know they're completed. Madam Speaker, my learned colleagues spoke about a very serious issue, and I want to tell the Honourable Member for St. Augustine that the issue of fraud that he spoke about and that harrowing experience which he personally shared with us today is something that is infradig, should not be tolerated, not because it's my learned friend, my good friend, the member for St. Augustine. I've known him for many years and I too have equal regard for him. It's not because it happened to him, because he's my friend, but because it has happened to so many people in Trinidad and Tobago. And I join him in pouring scorn and contempt on that. But Madam Speaker, this bill This bill, which brings to life the act, is designed to treat with that fraud squarely. And let me tell you how. First of all, Honourable Member for Caroni Central, the bill does treat with fraud. You must remember when your leader, the member for Siparia, poured scorn. Oh, what's the difference between guilt and contempt? Guilt and the manner and telling us, oh, this is a minor thing. It's not a minor thing. If you read the bill, you will understand that when we were treating with fraud, in clause 21 of this bill, we're amending section 81 of the Act, and section 81 of the Act treats with fraud. So it's unfortunate that members opposite haven't read the bill to understand we are treating with fraud. Quite properly so, Madam Speaker.
them.
But Madam Speaker, when we're treating with the fraud that the Honourable Member spoke to, let me break it down in simple terms. This... Sure, procedural motion? Forgive me.
Thank you very kindly, Madam Speaker, as I rise. Sorry to interrupt the AG, teaching them a lesson. Earlier. Madam Speaker, in accordance with Standing Order 15.3, I beg to move that this House, 15.5, I beg to move that this House do sit until the conclusion of the bill that we are currently debating. Thank you very much, Madam Speaker.
Honourable members, the question is that the House continue to sit until the conclusion of the business before it. Those in favour say aye. Aye. Any against say no. I think the ayes have it. The Attorney General.
Thank you, Madam Speaker. May I ask, what time am I bound to end?
Well, you have until 7:47 normal time, an additional 15 minutes.
Thank you, Madam Speaker. So, Madam Speaker, I was talking about the unacceptability of fraud. I'm hearing come across the floor from Naparima I'm teaching him nothing. I want to say I believe that Naparima is not capable of being taught, Madam Speaker. So I don't dare to exercise myself in futility, Madam Speaker. I am speaking through you to the people of Trinidad and Tobago and those who are willing to learn and understand what this law is about. Not Naparima, Marie Le Pen. Marie Le Pen. So, Madam Speaker, let's talk about fraud. This bill has in place the bring to life of the Act itself. Number one, the Act proposes an indefeasible title, subject to Section 34.2, and Section 34.2 of the Parent Act says, Section 34.2 of the Parent Act says that there are certain conditional aspects that bite into title. Number two, the bill and the Act speak to the effect of registration. How registration happens, when it happens. And if I take a little small point to answer my learned colleague, the Honourable Member for Oropuch West, who I think gave a good presentation this afternoon and certainly demonstrated some good research on her part, I wish to say that the Act does provide for the mechanisms of in-transit. The registration process, what happens during death, registration of deeds of gift, as another member raised, the Honourable Member for Caroni Central raised it. Section 41 of the Parent Act does treat with that. There is no interruption for the regular processes. What this law really is, Madam Speaker, it's a compulsory version, slightly cleaned up and tightened, of the Real Property Ordinance, now Real Property Act. That's what it is. The failure of the Real Property Act was because it was voluntary and therefore only 20% of land in Trinidad and Tobago found itself there. And that is directly related to the issues in Tobago. Because in Tobago, that beautiful part of our Twin Island Republic was savaged by a failure to launch this legislation because the land registration process in Tobago, Madam Speaker, involved people having to go to Tobago, going to court to bring lands under the Real Property Act, spending $60,000 odd per application. But let me give you the statistics on that while I'm at it and on this point before I come back to fraud. Number of RPA applications by year, that's Real Property Act applications, where you bring lands, you cure your title defects by bringing them under the Real Property Act, the provisions of the Real Property Act. It's called quieting of title. In 2011, there were 13. Number approved by the court, 7. 2012, there were 13. Sorry. In 2012, there were 13. Number approved by the court, 3. 2013, there were 11. Number approved by the court, 1. 2014, there were 8 applications. Number of court applications approved, 2. 2015, there were 7. None approved. 2016, there were 7. None approved. So this RPA system in Tobago just isn't working. And when we get to next week's debate, God willing, we'll explain how the solution will be found in the other debates. But Madam Speaker, in relation to fraud, this is directly related, and I'm going to answer not only the issue of fraud raised by St. Augustine, but I'm also going to peg it to some of the complaint offered in relation to Clause 20, which treats with Section 73 of the Parent Act. And that is where we limit the manner in which searches can be conducted. And we've brought about this amendment that the member for Siparia has raised, that the honourable member has expressed concern over, which is where we separate out attorneys at law and their clerks, and then members of the public. And in Section 73, as we amend it, we are proposing attorneys at law and their clerks can access the title. Members of the public access it electronically. Column, please. Members access it electronically. I'm so sorry. Members access it electronically. And then what we have is a manner of consent. You see, the reason why we've put a protocol around access to the manual records is very simple. Number one, the Data Protection Act and the system of registration will always ensure you have a manual record. So there'll never not be a manual record. Number two, the electronic record runs in tandem with the philosophy behind the Electronic Transactions Act and the computerization and digitization of the registry, which leads to ease of doing business. 73 days being cut down to several days. 9 procedural steps being cut down to 1. But importantly, there is a necessity in amending Section 73 as we do to limit the protocol for the same reason that St. Augustine complained about. Because when people access the books, the manual books automatically, that's where they pull out the deeds, do savagery, come up with fraudulent deeds, and there's no way to say which one is real or not, and therefore people get fooled. And what we're doing here is a direct anti-fraud mechanism which protects from the very circumstance that my learned friend complained about. So I think that it's now clear that this is a progressive step, but let me explain further why. In the system of registration of land, titling that we're doing in this bill, what we're really doing is we're saying, when somebody is going to conduct a transaction in relation to this land, the people consent that the title is going to be checked, that the indefeasibility of title subject to Section 34(2) is checked, and we freeze transactions so that the title can be better guaranteed. Instruments come in, they line up. When the titling is over, they fall in the order of priorities received to be registered. But nobody other than named authorized people with PIN codes, with access codes related to their birth certificate number, their unique identification number, we know who went there, who saw it, and what happened. And this, therefore, runs to the heart of a massive issue in our country of fraud. And that's why we saw this amendment to Section 73 proposed by Clause 20 as such an important and massive step for the protection of the citizens of this country. Now, Madam Speaker, this obviously affects the whole raison d'etre of our Follow the Money campaign. We run it alongside something else that is coming, which is beneficial ownership disclosure. We run it alongside something else which is coming, which is declaration of trusts in certain careful circumstances. So you can no longer hide behind trust mechanisms. Again, an abuse which rooted and is rooted in pure criminality in most instances. So, Madam Speaker, it is not by mistake that we are only here now 2.5 years later, because we have done massive work to coordinate ourselves to get here. And let me speak now to this allegation. Naparima, I need no help from you. Give you a chance. Excuse me?
He was looking down when he said it.
Observe Standing Order 53. I would ask members to conduct themselves in a parliamentary manner and please to refrain from the cross-stroke. Please,
Thank you, Madam Speaker. Madam Speaker, it's okay. One cannot take an insult from a man that hangs his head while he's trying to offer a threat. It's just not right. It's like a tail between the legs when they're trying to bark. Thank you, Madam Speaker. Madam Speaker. Yes, I agree. Naparima is insulting Karani. I agree. He should go on assist. Madam Speaker.
Just 1 minute, please. This is the last time I'm going to stand up and ask us all to behave in a manner befitting of this parliament. And let's get on with the important business of the people. Attorney General.
Madam Speaker, let's deal with the state of the registry. I thank the Honourable Member for St. Augustine for having the courage to admit that he did not renew the license. For the first time, I understood why. Because the Honourable Member said, look, he found it infradig that the renewal of the license would involve someone else owning the source data. However, I wish my learned colleague had renegotiated the contract. And I'll tell you why. We've done the same. We've renegotiated to make sure that we have escrow arrangements for source data, to make sure that we have ownership of data, that we have backup of data, etc. Because it's open to renegotiate contracts. Contracts aren't cast in stone. They can be renegotiated. There may be consequences for renegotiation, but one always has the liberty to renegotiate. The prejudice, and I say this reluctantly again because I confess of my friendship with the learned member for St. Augustine. The problem in allowing the system to collapse, as happened in July 2010, Madam Speaker, is that the entire system was left without support. And therefore, it cascaded into a very severe restriction beginning on January 23rd. It resulted in the Ministry of the Attorney General and Legal Affairs having to engage, thankfully, in the acceleration of work that we had already begun, because we had already backed up, we'd already data managed, we were already looking at an improved data migration to cause our move. So we were working assiduously for 2.5 years on it. Fortunately, I'm able to say the system has been tested over the last 2 days and is working. In fact, I spoke with the head of the Titling Association today. I spoke with the conveyancing arm of the Law Association today. I'm meeting with the Bankers Association.
Honorable Attorney General, your original 30 minutes are now spent. You are entitled to a further 15 minutes if you wish to avail yourself of
Should it please you?
You may proceed.
Thank you, Madam Speaker. So the system is live. We are testing it right now. We're stress testing it. We have backups of the system. And we have managed, by the grace of hard work, by the same people that I heard some members unfortunately refer to as incompetent. Incompetent institutions were reflected upon by members opposite. And it is those same institutions negatively reflected upon by members of the opposition that have come to the rescue of a system which was abandoned on July 13th, 2010 by the last administration. And Madam Speaker, I wish to also thank sincerely the members of the association that worked alongside, because Madam Speaker, the manual system was still operating, you know. There's always manual access. The PIMS online system, Property Information Management System, is what PIMS stands for. That system allows you not to abstract title, but to pull up the images for title which you wish to abstract. So that's not the way the system operates. That system, in fact, operated down at the registry, which is why I said it was a limited system. We had access points to that, and the country books were available, and the copies from the manual searches were available, so titles still proceeded. And I can't see why honourable members opposite would have taken such joy as Oropuch East did, joy as other members did in saying and in alleging that there was a collapse of the system. For heaven's sake, Madam Speaker, if you caused the collapse, what you celebrating about?
So there is.
What are you celebrating about if you are admitting you failed to pay the license and you cause the system to go into jeopardy? What is so gleefully good about that? Not even a thank you to the hardworking people at the registry and the IT professionals for rescuing the system from your own negligence or dereliction of duty. I mean, Madam Speaker, let me tell you this. In relation to the strengthened information management system, I wish to say it's true that the IDB has funded that position. The project, as was scoped by the UNC government, involved a lack of inclusion of the heart of the material to be scanned. Let me explain that. 20% of your records are in the Real Property Act. 80% of your records are in what we call the old law section. Your project was to scope the 20%. We rescoped the project, thank God, in 2017 to do the whole 100%. Because 80% of your registered title is in the old law system. So when you miss the boat clean, try not to celebrate too fast now. Madam Speaker, let me put it this way. We have managed for the period December 2016 to February 2018 to scan 413,451 records. We have managed to do 1,071 pre-1970 deeds, 42,012 records in the RPA system. We will, by the end of the next 12 months, have finished 5.8 million scans because we have accelerated the system of data entry. And that has been specifically done to operationalize these laws that we are bringing now. Much like why you allowed me that latitude to explain how important the operationalization of the Family and Children Division is, as it is to this, Madam Speaker. You see, we're very conscious that we will be judged on what we have performed. And whilst we are at midterm, and whilst the financial position is extremely difficult, because of very bad choices made by my learned friends opposite, the point is, we know that we must account for what we do, and this is an example of what we are doing, Madam Speaker. Madam Speaker, the country will pronounce. My learned friend for Caroni Central is correct. The country will pronounce.
3 times.
Madam Speaker, once we have finished and launched our property business registration solution, we anticipate we'll be able to drop the registration time from 11 days to 1 day. Madam Speaker, we expect that this is the correct way that one ought to approach this position. I want to say that honorable members opposite saw the leader of the opposition talking about the ease of doing business, reflect upon, listen to what the honorable leader reflected upon. Trinidad and Tobago has slipped. Look at the following countries for ease of doing business: Guyana, Jamaica, Belize, Barbados, Grenada, Antigua. They all have the system we want to implement today, Madam Speaker. At least compare apples with apples, mangoes with mangoes, watermelons with watermelons, Madam Speaker. This is exactly why we are on the Parliament floor today talking about a compulsory system which resembles the old torrent system in an improved version. That is why we are here. And if the honorable members opposite can't understand that, God help us all. So, Madam Speaker, we've done the homework. This bill is logically oriented with several other work products. The operationalization is well afoot. We expect to be moving into the registry at the Richmond Street campus, the Attorney General and Legal Affairs building, beginning April, ending in June. We expect that the squalid positions of accommodation, which my learned friend spoke quite correctly about, the Honourable Member for St. Augustine, will be a thing of the past. When Tropical Storm Brett was threatening that night, Minister Young and I were making sure sandbags were down at the registry. Army was moving because we know the flooding situation. Mr. Francis Sandy, Deputy Registrar, was down there in the night, wind blowing hard, making sure bags were being stacked alongside the ODPM and the Army to protect the records of Trinidad and Tobago. But, honorable member, when the last government took $1 billion and took 5 years to complete a completed structure, $1 billion and 5 years to complete a completed structure, because it was completed in 2010, and you fail to arrange your vault system for the registration books of Trinidad and Tobago, because, Madam Speaker, that is the same position that the Honourable Member for Caroni Central reflected upon. It is land, it is ownership that deals with capital and growth. But for heaven's sake, you're going to put those books with the water on top of the book? When the fire breaks out and the sprinkler system is directly on top of the 1882 books for Tobago, that is planning? Turn on the tap and wash away all the books? Madam Speaker, what passed for planning and logical arrangement under the last government? I don't know. I am sure that my learned friend for St. Augustine had nothing to do with that. I am sure. Because Madam Speaker, I walked into the vault and I was just shocked. Madam Speaker, all I know is the $1 billion bought sprinklers, and they weren't modified. And there's nothing wrong with the water sprinklers. It's the locationing. And then it's the gaseous supply that you have over that. Madam Speaker, the point is, you can't just talk, Madam Speaker, respectfully. You have to be prepared to walk the ground, visit the sites, stand up in the line with the people, as I do, as I heard my learned friend for St. Augustine did when he was minister there. He was very often down on the floor, as I am. But the point is, I have given a personal commitment to the Registrar General that the majority of my focus this year is at the registry. Because, Madam Speaker, that's the gift that is going to continue to give Trinidad and Tobago blessings, not only for the capital growth that my learned friend for Caroni Central so correctly pointed out, but importantly, it's going to allow this country the opportunity to pursue criminality in a way that has never been done before. And it's high time that Mr. Big or Mr. Little suffer the consequence of having their illicit wealth identified and treated with under due process. Madam Speaker, I've heard not a single amendment offered on the floor. I therefore hope that the committee stage will be a relatively peaceful one, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Registration of Titles to Land Act 2000 be now read a second time. All in favour say aye. Aye. Any against? The ayes have it.
A bill entitled An Act to Amend the Registration of Titles to Land Act 2000.
Attorney General.
Madam Speaker, in accordance with Standing Order 68-1, I beg to move that the registration of titles to Land Amendment Number 2 Bill 2017 be committed to the Committee of the Whole.
Honourable members, the question is that the registration of titles to Land Amendment Number 2 Bill 2017 be committed to the Committee of the Whole. All in favour say aye. Aye. Any against? The ayes have it. This House will now go into the Committee of the Whole to consider the bill clause by clause.
clauses 1 to 19.
The question is that clauses 1 to 19 stand part of the bill. The question is that clauses 1 to 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 1 to 19 now stand part of the bill.
Clause 20.
The question is that clause 20 stand part of the bill. Member for Point of Peer.
Thank you, Chair. Today, Attorney General 20B, deleting the word any person and substituting attorney at law. Could you just, for clarification, why that change?
I'd be very pleased to. I wish to express that I do understand the concerns raised by my learned friends opposite. And if you'd permit me, Madam Speaker, Madam Chair, to address that. So the Clause 20 proposes an amendment to Section 73 of the Parent Act. And when we look to Section 73 of the Parent Act, originally 73 said that any person may, on making an application in the prescribed form and on paying the prescribed fee, inspect any folio, etc., require an official search to be done, etc. And we ended there. What we did was to separate out the manner of access for different classes of persons. In the first instance, we prescribed by the introduction of a 73(1) that attorneys at law or their clerks, and we put in who hold valid practicing certificates, etc., can make the application for search in the prescribed form. And we did that so that we could tag on the anti-fraud mechanism, so you know who came, who checked, and how it was done. That's to be read alongside with subclause 2, which this amendment also proposes, which is that any person, meaning anybody else, may make an application in the prescribed form and be entitled to a certified copy of any folio, parcel index, etc., in the registry. Now, that subclause 2 is the crux of the difference between a search and obtaining copies. Because when you request a certified copy, you get a certified copy of what you have looked at. It means that you don't necessarily need to access the manual copy, but the registry certifies that that is the registry's version of the manual copy which you would otherwise have accepted and inspected. And you get that produced in your hand as a certified copy or counterpart, if you want to call it that. It's not quite a counterpart. We then added subclause 3, which says a member of the public may search the electronic records. Again, you have the ability to order certified copies. It's when we get down to the next clause, subclause 4, that we're really talking anti-fraud. Any person proposing to deal with registered land has, with consent in writing from the proprietor, applied for an official search. That takes care of the exact example that my learned friend, member for St. Augustine, raised, where somebody rolled up, and I'll use it hypothetically now, and said to the police, I have a deed for this property. I own the property. He couldn't in this circumstance have done that because he would have to have had his predecessor in titles written permission that he could actually search the title and then go into the searching title phase where we freeze time. So this is a huge anti-fraud protection because it is only the person who has the thing in his hand that can say, yes, you can search my property in the manner that we mean in legal search, not just an average inquiry by the public. It's still a public register. You could still go online. You could still request access. You can still get certified copies. All of that is mutually exclusive from the arrangement of a legal search parameter. And Madam Speaker, that in essence explains why we have disaggregated Section 73 in the manner that we do in this bill now. I hope that brings some comfort to my learned colleague.
So you want to stay with the any person note, on that?
If I were to simplify it, and I know it's, forgive me, as a practitioner myself in this field, I understand the field well, and maybe I've been a little legal. The bottom line is the public, John Brown public, has access to the full records there. John Brown public can search. John Brown public can get electronic copy access. John Brown public can get physical certified copy access. So we're not denying the right of the registry being truly public, which is the purpose of a public registry.
I agree with it. Okay.
The question is that clause 20 now stand part of the bill. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it. Clause 20 now stands part of the bill.
Clauses 21 to 23.
The question is that clauses 21 to 23 stand part of the bill. The question is that clauses 21 to 23 now stand part of the bill.
Could I ask a question, Madam Chair? I had raised the issue of fraud having to do with fraudulent activity within the registry itself. Yes. Where is that addressed in the bill?
Sure, I'd be very pleased to raise that. Madam Speaker, Section 81 of the Act is amended at Clause 21 of the bill. Clause 21 says Section 81 is amended by deleting the words "is guilty of" and substituting the word "commits." When you go to Section 81 of the Act, it's entitled Offences, and it reads, "Any person who fraudulently procures, assists in such procurement, is privy to any destruction, alteration, or attempted destruction or alteration of any record, instrument, or document lawfully recorded in the land registry. B, fraudulently uses, assists in, or is privy to such use of any form purporting to be issued by the land registry, commits an offense and is liable on summary conviction to a fine of $20,000 and to imprisonment for 2 years, and on conviction on indictment is liable to a fine of $100,000 and imprisonment for 5 years." So it's squarely captured. And Minister Hinds raised the importance of the constitutionality in re-expressing it this way, because otherwise we'd run afoul of the rule of being guilty, of being innocent until proven guilty.
Member for Carney Central, is that all right? Are you satisfied? Do you have any further questions?
I'm not fully, but I'm not prepared now to argue the issue.
Okay. The question is that clauses 21 to 23 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 21 to 23 now stand part of the bill. Honorable members, the question is that the bill be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The House will resume. Attorney General.
Madam Speaker, I wish to report that the registration of titles to Land Amendment Number 2 Bill 2017 was considered in Committee of the Whole and approved without amendments. I now beg to move that the House agree with the committee's report.
Honorable members, the question is that this House agree with the committee's report on the registration of titles to Land Amendment Number 2 Bill 2017. All in favor say aye. Aye. Any against? The ayes have it. Attorney General.
Madam Speaker, I beg to move that a bill entitled "An Act to Amend the Registration of Titles to Land Act 2000" be forthwith read a third time and passed.
Honorable members, the question is that a bill entitled "An Act to Amend the Registration of Titles to Land Act 2000" be now read a third time and passed. All in favor say aye. Any against? I think the ayes have it.
A bill entitled "An Act to Amend the Registration of Titles to Land Act 2000."
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to Friday, the 23rd day of March, 2018, sorry, to Wednesday, the 21st day of March, 2018 at 10 a.m. On this day, we will be doing an act to amend the Land Adjudication Act 2000, an act to amend the Land Tribunal Act 2000, and depending on the time, Madam Speaker, we will also do an act to repeal and replace the Crown Suits Limitation Ordinance. Thank you, Madam Speaker.
Honorable members, the question is that this House do now adjourn to Wednesday, the 21st of March, 2018 at 10 a.m. All in favor say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Wednesday, 21st March, 2018 at 10 a.m.